Is Jake Cosgrove and Brianna Crenshaw here? Is Brianna Crenshaw here? Is Lorenzo Bell here?
Good morning, Your Honor. That is my matter. Lorenzo Bell is represented by counsel, and counsel and I are about to enter into a breakout room and come back in here, if that's okay.
That's perfectly fine. Good morning.
Thank you. Thank you, Your Honor.
You're welcome. Good morning, Attorney Adams.
Good morning, Judge.
Is anyone here from 18443 Burrell Street? Ronald Reason? Ronald Reason. I don't see a Ronald Reason. I wish he was here. We have so much time this morning.
No, I don't see him on the list either.
Yeah, it's not too many. It's not too crowded in here.
No, it's not. You're right. It's not crowded this morning.
Very, very peaceful. All right, let's keep an eye out.
Okay.
We have a lot of 10 o'clock cases. Well, not too many, but until 10, there aren't too many cases. So we should be able to get through the early docket. And I'll call default to 10. So let's see Kimberly. Attorney Lawan. Good morning, Kimberly's iPhone. Good morning. Oh, you're still connecting.
Oop.
Good morning, Kimberly's iPhone.
Good morning.
Good morning. What case are you on?
Let me give you the two case numbers. Case number ending in 7204 and case ending in 7205.
Okay, so you're the landlord. Right, I have you checked in. You're scheduled for 10 a.m. So you really have time. Trumbull. Are any of your cases dismissals?
No.
Okay. All right. I have you checked in.
Okay.
And we're just waiting on Asia Harris and Stasha Sumlin. So if they don't arrive by 11, I give everybody an hour. So you're scheduled for 10. If they don't arrive by 11, I can call a default. If they do arrive, they may get legal counsel. They may not. Just depends. Whatever they want to do, and then we'll call the case.
Okay.
So if you want to log back in, feel free. If you want to stick around, it's up.
Okay. I'll log back in at 10.
Okay. All right.
Okay. Thanks.
Good morning, Ms. Veneer.
Oh, good morning. I'm on now. Okay, good morning.
You are on. Good morning. What case are you on, Ms. Veneer?
I am the owner of 14969 Promenade Street.
Okay. Do you have a case number?
Yes, 1 second, sorry. I wasn't organized.
Good morning. I had a court date at 9:30 today.
It's 2334-7180.
Okay. It was Attorney Spaniolo. And your name is Costello Munir.
Yes,
Now, do you have an attorney, Ms. Munir?
yes, he should be there.
What is your attorney's name?
Oh, I forgot his name, but he
What's he
came
look
from,
like?
I forgot his name, but he's from United Housing Coalition.
Okay.
Yes, he should be there. He told me he would be here today.
All right, well, I'll have you checked in.
Okay, thank you.
You're welcome.
And I'm sorry, Your Honor, this is Attorney Brayley. What, that was the case ending in 108. And what time is that set for?
180.
180, yes, okay.
Set at 10 o'clock with Everness LLC in Spaniolo.
Ah, yes, that would be Mr. Barashai, and he's aware and he will be here at that
Okay.
time. But if something happens, I can cover for him as well.
All right. Okay.
Thank you.
So Ms. Munir, your attorney is Attorney Barashai.
Oh,
And you're scheduled for 10 o'clock. So you have a second, but don't, it's about, yeah. You have about 30 minutes.
okay, thank you.
You're welcome.
Your Honor,
Mr. Sartorio.
good morning. I'm checking in at 9:30. Lakita Thornton, it's a 4139 of the last 3 digits, and she's here as the iPhone, I believe.
Ms. Thornton, good morning.
Good morning.
It's hard to hear you on your phone. I don't know if you have your hand up, but just keep that in mind.
Okay.
I have checked in.
Thank you, Your Honor.
You're welcome. Good morning, person who just logged in on the iPhone.
Hello,
Good
this is
morning.
Hal Burke. I'm gonna rename myself. I have Beaumont Health versus Fikes. Thank you.
Beaumont Health.
Yes, sir.
What time is your case scheduled?
It is set for 9:30. Beaumont Health versus Fike. I can give you the case number if you need it.
Yes, please. It was the case number.
22197757. Is that still on your docket?
One sec. Judge Hennett Johnson. Oh, you're in Judge Hennett Johnson. Let's see. Judge Hennett Johnson. She's in 536. Oh, this is 436.
Oh, I
You're-
apologize.
No worries.
Would you say that right Zoom number, please?
It's 360
Yes.
536 0000.
Thank you very much. Have a great day.
All right, you too. That Johnson, Tina Johnson.
Right, I guess so.
Yeah, she's. Who has the tone? Is Tamara Bolden here? Good morning, Ms. Bolden.
Good morning.
All right, are you being represented by Mr. Featherston?
Yes.
Like the other side is here. Good morning, Ms. Mason. Good morning, Ms. Mason.
I apologize, Your Honor. Did you just say somebody here was being represented by Mr. Featherston?
Is Mr. Featherston still with you all?
He is, yes. I just didn't see that on our list this morning, so I was hoping you could tell me which case that was.
It is case number 22394910.
22394910.
22394910, Latonia Mason versus Tamara Bolden.
I'm here, Your Honor.
Good morning, Ms. Mason.
Good morning.
We're looking for the Ms. Bolden is here, and we're just waiting on her attorney. Mr. Narsigian.
Hey, Judge, we have resolutions on both of my cases whenever you're ready.
Calling case number 23346898, Open Door Property Management versus Regina Williams.
Sean Norsegian P 77410.
Good morning, Your Honor. Eleanor Karagian, P8696 with UCHC on behalf of defendant Regina Williams, who is present in the gallery. Ms. Williams, please state your name for the record.
Regina Williams.
Good morning, everybody. Ms. Williams, we saw you here. What's going on? You all have a resolution in this?
Yes, we do, Your Honor.
All right, who would like to put the terms on the record?
I can go ahead and do that. We are going to be doing a conditional dismissal with a pay or vacate date of July 1st with box 4B checked.
All right. Check. So this is pretty straightforward. What's the pay? What's the amount to pay?
$1,946 of rent plus 150 in court costs. for $2,096 total, Judge.
All right. So do you understand 4B, Ms. Williams?
Yes, I didn't know the amount was that much, but okay.
Okay, so 2096 must be or party must vacate on or before July 1st. If that occurs, this case is dismissed. If that doesn't occur, either one of those conditions, then a judgment and a writ of eviction can be filed without us going back to court.
Okay.
Okay. Do you give Ms. Karijian consent to sign your name?
Yes.
All right. The noise of babies, I'm used to babies, Ms. Williams, so
Because he is just.
don't worry about it. All right, you're free to go. Just talk to your attorney if you have any questions, and good luck.
All right, thank you.
You're welcome. Calling case number 2334-6899. Open Doors Property Management versus Colette Davis.
Sean Norsegian, P77410 on behalf of plaintiff.
Eleanor Karagian, P86696 with UCHC on behalf of defendant who was present in the gallery. Ms. Davis, please state your name for the record.
Colette Davis.
Hello, Ms. Davis. Hello. All right. This was originally filed as a complaint for non-payment of rent. The lead parties have a resolution. Who would like to put the terms on the record?
I can go ahead, Your Honor. So this case is going to be a conditional dismissal with a July 1st pay or vacate date, and box 4B will also be checked.
All right, and what is the amount to pay?
The rent owing is $3,168, $150 in court costs, total $3,318.
Right. Okay, 3,000. Go ahead. What did you think it was?
I thought it was back pay. I don't know where the extra $1,000 came from. On my record, it was $2,000.
It's June 1st. It's June 1st. It's June 1st. So add 1,300 to whatever your records are.
Oh, okay.
But it's the first of the month, so that's probably where you're off. But is that?
But I get assisted with housing. I know for sure I paid my part this month, and I got a letter from them stating that they are going to pay their part this month. But as far as like this month, that rent is already paid. I'm just on the back end.
All right, so what number did you have?
I have I know it was like 2,000, and all of that is like back pay from the beginning when I moved in here. And housing was, huh?
Let me cut you off. Do you have a ledger? Are you keeping track? I'm not going to penalize you for not keeping track, but if you say his amount is wrong, you've got to be able to give me the amount. And you need, the
way he said it is correct. It's correct.
Okay, I mean, I don't have an issue with you objecting to it. I just want to make sure you're clear, and then moving forward, just keep a ledger, you know?
Okay.
So is this, Mr. Narsegian, is this the section 8 amount portion included in this 3318?
No, it's not, Your Honor. So her portion is $571 per month. So when I filed this thing,
I'm sorry. Okay.
Let me explain, and then you can just correct him if he's wrong.
Okay.
Okay, so her portion is $571 a month. When I filed this in April, the balance was $2,026. If she made a payment of that 571 in May or anytime after April 21st, then I can credit that. I don't have a record of it yet. That doesn't mean she didn't do it. But that's what she owes. Section 8 pays 729 and she has to pay 571. So I added for June and for May, which is how we ended up at our number.
Okay, so Ms. Davis, we just put on the record, he just put on the record how he said any payment that was made after April 21st may not be accounted for. So if you have proof of payment after April 24th, then that accounting will be adjusted accordingly with your property management. Now, what else did you have to say, Ms. Davis? Oh, you're muted.
I'm sorry for interrupting him, but the paperwork and all of that changed because I got a copy from housing and all of that is different because from the time I came down here, I just transferred down here from Indiana and housing was supposed to be covering a couple of months and I didn't know who my caseworker was. I only found out who my caseworker was probably like 3 weeks ago when I was in court. So I had to talk to housing, talk to their big bosses and all of them, give some paperwork. I'm in the middle of sending them a paperwork, but they do owe that back pay. But as far as me owing 5, I don't owe 5 no more. My rent and stuff got layered. So they kind of like working on my paperwork now.
Okay, so we'll enter this conditional dismissal and get some clarity on your numbers in the meantime, and if it's adjusted or needs to be adjusted, I'm sure counsel will work with you.
Okay, it's no problem.
Okay, but just stay on top of things, Ms. Davis.
I will.
All right, any other questions?
No.
Okay, so there's a conditional dismissal with 4B check where there'd be a payment or parties will vacate by July 1st or pay $3,318 by July 1st.
Okay.
And if you have payments or you have any other arrangements, please get them in writing and keep track of your payments because you're within, you have control of your situation. So just make sure you keep your documentation so you can explain your side.
Okay.
All right, good luck, Ms. Davis. Thank you, counsel.
Thank you, Your Honor.
Thanks, Judge. Take care.
You're welcome. Is Kriana Crenshaw here? Kriana Crenshaw. Let's see, Attorney Hall, good morning. Who was here looking for you? Oh, Mr. Sartorio.
Yes, Your
Honor. Dana Hall is here for Attorney Gann. If you all didn't talk already, I just wanted to.
Yeah, we have a little bit. So he just told me she's moved. I'm just gonna verify that she's moved out and then we can dismiss.
Okay. All right, we have some time this morning. It's very quiet in here, so I wanted to take advantage of that. So whenever you're ready, just pop a hand up. Let's see, it's 9:40. Mr. Martinez.
I think we're ready on the Bell case. I believe it ends in 4189.
All right. Okay.
Yes, good morning, Your Honor.
Hold on 1 second. Good morning, Bill. Good morning. Calling case number 2334-4189. This is Doyenne Detroit LLC versus Lorenzo Bell and all occupants.
Good morning, Your Honor. Attorney Ali Ajami appearing on behalf of plaintiff in this matter.
Good morning.
Good morning, Your Honor. James Martinez, P86604, standing in for Attorney of Record, Easton Nashwatt.
Right.
Your Honor, this is a third hearing for a termination of tenancy case. I did have the opportunity to speak with Mr. Martinez regarding this case. We did agree to submit a judgment by hearing to the court with a move out date June 12th, 2023. 4B will be checked. No money damages, no money judgment.
No money. Okay, let's see. This was a complaint for non-payment of rent. Oh, no, it's a termination of tenancy as stated.
The one thing I would add, Your Honor, is it would be to all occupants.
Okay.
Yeah, so judgment against Lorenzo Bell and all other occupants.
So it'll be a removal of Lorenzo Bell and this a judgment will go into all occupants. Parties agree on that?
Correct, Your Honor.
Yes, Your Honor.
Okay, I'll enter this as a judgment by hearing. All occupants must vacate by June 12th, 2023, or writ may issue.
And that's 4B, right?
Yeah, well, what's 4B on the judgment form? Let's see.
Oh, I'm sorry. Yeah, it says the plaintiff can apply.
It's still 4B,
Yeah.
attorney, but we're just usually it's referred to on a conditional dismissal, but 4B and also 6 is very important. So if you the box is 6, obviously, I know this doesn't apply to this one, and 7 is no money judgment entered, but we'll be back in person next week, so we don't have to announce any of this. We'll see it, and I'll read it at the bench.
Very nice.
Acceptance of partial payment. We'll be back to.
So to be clear for this one, when I was filling out the proposed judgment or the judgment to be submitted, I checked box 6, and it will not prevent the court from issuing an order of evicting the defendant.
Well, yes, you're not asking for any money, so it'll be 4B.
Okay, so you want me to leave 6 unchecked then?
Yes, 6 is irrelevant. 7, you mentioned on the record, no money judgment is entered at this time, and you're in good shape.
Okay, and now the court would like me to either email or fax it over, or will the court be issuing its own copy?
I'll let you just email it to the court. And
Okay.
I pop email in the general chat. So if you email it to the court, just mark it as a hearing. And then I'll sign it.
In the subject line, should I put?
Just put the case number. Just throw the case number. So if it ever gets lost, we can search it.
Thank you very much, Your Honor.
Go ahead.
So about a week and a half ago, I was before you, Your Honor, asking about a couple cases in front of you for a status follow-up on the order for eviction. I know you have like 4 or 5 stacks of piles to go through. It has been a couple of weeks. Would I be able to send a runner to the courthouse later today? Or should we just wait? I guess
if you want, you can send someone.
Instead of going to the clerk window, should I have them come to your courtroom, Your Honor?
Yeah, my clerk's in the courtroom, so he may be able to assist if you come up here. And then we're getting piled down, but it's still a pile. So
okay, is there a good time for me to send my runner?
The earlier the better, or 1:30 to the earlier anytime not between 12:30 and 1:30. So,
Not between 12:30 and 1:30. Okay. Thank you very much, Your Honor.
you are welcome. All right, Mr. Fawaz.
Morning, Judge. How's it going?
Going good. How are you this morning?
Good, good. I have a conditional dismissal to place on record.
Fantastic. All right, calling case number 2334-7258. This is KPM Detroit LLC and Jake Cosgrove versus Creona Crenshaw and all occupants.
Yusuf Fawaz on behalf of the plaintiff, P number 83664. We actually got this one decided, or we entered the terms in last time we were here, but we never put it on record. We just sent in a conditional dismissal order, but I don't think the court received it yet. So we're just I'm here to put it on record. Is that fine?
Yes, and we're going to verify if we have it in the system.
Okay. The landlord agrees to waive the rent owed up until July 1st, 2023, on the condition that the tenant vacates the premises on or before July 1st, 2023. Tenant agrees to vacate the premises on or before July 1st, 2023. So we also checked off 4B on that.
Okay, and this is a conditional dismissal, you said?
Yes.
Okay, so vacate by July 1st, all rent is waived if defendant vacates by July 1st?
Yes.
Okay, all right, and that's been submitted, signed and submitted to the court?
Correct.
All right, well, you're all set, Mr. Fawaz. Thank you for letting the court know.
All right, thank you, Judge.
All right, we're in person on the 5th and moving forward.
Oh, man. Is the first hearing also in person?
First hearing is in person, but first hearings get automatic second hearings. So if you have a proposed resolution, it may be useful to appear at the first hearing, or, you know, if you really need to work with the other side, but you don't know who's retained yet either at the first hearing. I'll leave it up to you on whether the first hearing is in person for you, but we will have an automatic second hearing, so I'll leave it up to you on that.
Okay.
Because you're getting that second court date anyway, so. But you may get a resolution at the first one, so I can't tell you what to do, counsel. Have a great day.
I'm like, come on.
I'm not gonna tell you not to come, but we will have 2 hearings, so.
We'll get it figured out. I'm sure it'll be fun.
Yeah, you get a system going, you get the group. You might have some traffic tickets, and you know, the same day you have the first hearing.
You guys might see me a little less.
We'll see. I'll be here.
All right, Judge, you have to go on.
Thanks. Mr. Bearshot, good morning.
Good morning, Your Honor. How are you?
Doing well.
Great.
You and Spaniolo have a matter.
We do, Your Honor. I need a co-host power so that I can speak with Attorney Spaniolo in a breakout room, but also before that, I have a conditional dismissal to put on the record.
Okay, fantastic. So snuck in here. Good morning. All right. What is the case number of your conditional?
Case ends in 4628, Your Honor. It's scheduled for 9.
Okay. Calling case number 2334-4628. This is Kendall Holmes versus Aisha Rupert and all occupants.
Good morning again, Your Honor. Tom Barishai, P83642 on behalf of Aisha Rupert. I don't believe plaintiff's attorney will be appearing today because we submitted a conditional dismissal for this morning.
Okay. And is there an amount to redeem on this conditional dismissal?
Yes, Your Honor. The total amount is $981. That includes $164 in court costs. So rent is $817.
Okay. So 981, and when is that to be paid?
That is to be paid in 6 monthly installments of $163.50, Your Honor, starting on June 15th.
Right, okay. Thank you for putting that on the record. We put that in the system and we'll sign it and get it back to you as soon as possible.
Thank you, Your Honor.
Well, we got this done. I see this case has bounced around, but there were short adjournments, so good work, counsel.
Thank you.
Welcome. Right, 9 o'clock is late. Ronald Reason here. Go ahead, Ms. Lawan, and then Attorney Adams.
Yes, Your Honor, I believe we are ready on 5681. I think this phone number ending in 9478 is Ms. Mathis.
All right, let's see. Mathis. You said, oh, was she in the waiting room?
No, I believe
Yes,
she's
Your
in
Honor.
the gallery. She just doesn't have it named. It's under her phone number.
9478.
Ms. Mathis, are you in the courtroom?
Yes, I am.
And we are ready to go, Your Honor.
This is Deborah Mathis versus Alonzo Benning.
Yes.
Calling case number 2334-5681. Deborah Mathis versus Alonzo Benning.
Good morning, Your Honor. Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Alonzo Benning. Mr. Benning is having technical difficulties, but so he's not in the courtroom, but I have his authority to act on his behalf. Plaintiff Ms. Mathis is in the courtroom. Ms. Mathis, will you state your name, please?
Deborah Mathis.
Good morning, Ms. Mathis.
Good morning, Judge.
I am happy to report that yesterday the parties agreed to a conditional dismissal. The terms are that Mr. Benning will pay Ms. Mathis 1 month's rent, which is a total of $400 by tomorrow. Again, he's having technical difficulties, so he will have it by tomorrow. And there is a move out date of June 30th. 4B is checked, and I emailed the conditional dismissal signed by both parties to your courtroom this morning.
All right. Thank you, counsel. All right, good luck, Ms. Mathis, and thank you, counsel. I know Mr. Benning wasn't here. We'll enter this conditional dismissal on receipt. And you are free to go, Ms. Mathis.
Thank you,
Thank you,
Your
Your Honor. Thank you, Ms. Mathis.
Ms. Mathis,
Thank you.
did you all already enter the conditional dismissal, Ms. Lawan?
I did.
Okay,
I sent
all
it
right.
to Ms. Mathis, and she gave me permission to sign her name.
Okay, fantastic. All right, you have a great day, Ms. Mathis.
Hey, you have a great day too, Judge. Bye-bye now.
How about, here it is right here, Chad. Okay. And I have the conditional dismissal, Ms. Lawan. We're almost working
Perfect.
real there.
Thank you.
Attorney Adams and
Yes, Judge, I believe Mr. Rowland is in the courtroom. And we want
Okay.
to
Yes,
enter
I'm
into a
in here,
consent
Judge.
judgment.
all right. You all have a consent judgment, you said?
Yes, that's what we'll place on the record and I'll email it.
Fantastic. Calling case number 2334-4574, Universal Real Estate versus all occupants. And that includes Mr. Ronald Reason.
Valerie Adams, P73324, on behalf of plaintiff.
Good morning.
Morning.
And Mr. Reason, can you state your name for the record?
Yes, Roland Reason.
Thank you, Mr. Reason. All right, counsel, did you say that you all had a consent judgment? Would you like?
Yes, Your Honor, the parties have agreed to a July 1 move-out date.
Okay.
And Mr. Reason, do I have your permission to sign the consent judgment reflecting the same?
Yes, ma'am.
All right, the court is satisfied and submit that to the court. We'll get it signed. The email is in the chat.
I have it.
Okay. All right.
Yep.
Okay, so it's whatever. If you want to fax it over, feel free, but if you email it, we'll scoop it up and sign it as well.
Okay, and then for a separate matter, I do have another judgment that needs to be signed. Can I email that over too?
Is it my courtroom?
Yep, it's in your courtroom. Yes.
Feel free.
Thank you. Have a good day.
All right, you too. Bye. All right, Mr. Reason, you have a great day as well, if you didn't log off yet.
Thank you, you too, Your Honor.
All right, thank you. Attorney Phillips, good morning.
Morning, Your Honor. At 10 o'clock, 6142.
On case number 2239-6142, Leonard Markham versus Engel, Bush, and all occupants.
Morning, Your Honor. Ted Phillips, P35900 for the defendant. The plaintiff is not represented, but in the courtroom, and the defendant is as well. Mr. Markham, could you go on, say your name?
Leonard Markham, good morning.
Good morning.
Good
Mr.
morning.
Ms. Bush, could you say your name, please?
Angela Bush. Angela Bush, good morning.
Yeah, the parties have came to a agreement on a conditional dismissal. I've sent a copy of that over to Mr. Markham this morning, and they've discussed it thoroughly with Ms. Bush. The terms are that there is $5,800 owed through May 31st, 2023. Defendant will pay the June rent of $700 by June 5th, July rent of $700 by July 5th. The writ may issue June 12th or later if the June is not paid. July 6th, if the July is not paid, the full balance will be paid by July 31st. A writ to issue and payment will be deemed timely based on when it is mailed. Mr. Markham indicated he would prefer it to be mailed to him, but mail is sometimes a little slow in Detroit, so we have that term. It is a 4B conditional dismissal. Partial payment will not prevent the issuance of a writ. I've also explained to Mr. Markham 4.201I, and that he has the right within 3 days to file a motion to set us aside if there's something he did not understand or if he feels that I misled him. That is the full agreement. I would just note additionally, Your Honor, this is the case where Ms. Bush's husband has been in Georgia for a while on hospice. They are back to Detroit at the moment. That's why this has been delayed so much. But she is expecting a lump sum check by July 31st to be able to pay the full balance. But that's the full agreement.
Okay, well, thank you for the update. I had 700 June 5th, 700 by July 5th, and then I missed the balance on July 31st. Is that what?
The balance is $5,800. That covers everything through May 31st. Mr. Markham wanted it done that way as opposed to adding June in right now, but whatever, comes out to the same.
Okay, all right. All right, and do you have any questions? Well, Ms. Bush, you don't have any questions, do you?
No, I fully understand, sir.
Okay, and Mr. Markham, it's good to have, welcome back home. I'll enter this conditional dismissal and good luck to all parties.
Mr. Markham, do I have your authority to sign for this, or do you want to sign and send it back to me?
No, you can go ahead and sign it. I appreciate it.
Okay, Ms. Bush, I have your authority to sign?
Yes.
Okay, thank you, Your Honor.
You're welcome. All right, you all are free to go. Keep an eye out for a copy of the CD, and Attorney Phillips, you can send that in either way you like, but email is pretty fast. Want to send it in by email, we'll sign it. All right. Attorney Hall.
Okay, have a great day.
What'd you say, Mr. Markham?
I say have a great day, Your Honor.
All right, you too. Thank you. Attorney Hall.
Yes.
Good morning. Are you and Mr. Sartorio ready on the matter?
Yes.
Yes, Your Honor.
All right. On case number 22394139, the Peterborough Farms Limited versus Laquita Thornton and all occupants.
Dana Hall, P 77966 on behalf of the plaintiff.
Your Honor, Anthony Sartorio, P 84851 on behalf of the defendant, Ms. Thornton, who is also present. Ms. Thornton, if you can state your name for the record.
Laquita Thornton.
All right, Ms. Thornton, good.
And Your Honor, we have a agreement on the matter. We'd like to request that the matter be dismissed without prejudice under the condition that the plaintiff may take immediate possession of the property and that any possessions left in the property may be considered abandoned.
All right, let's just write this. It said, the plaintiff may take immediate possession of the property, correct?
Yes, Your Honor.
Plaintiff may take immediate possession of property. What was the last term?
Any possessions left in the property may be considered abandoned.
Thank you for the mic. And the property may be considered all right, and this is a stipulation. This is a stip to dismiss.
Yes.
Yes, Your Honor.
You all, can you send it in, Mr. Sartorio? So
I can send it in. Yes, Your Honor. Ms. Hill, do you want me to send you a copy first?
No, that's okay.
I can sign on your behalf then?
Yes.
Thank you. I'll do so shortly, Your Honor.
okay, all right, thank you. And thank you, Attorney Hall. Is this your only case today in my courtroom?
Yes.
It's mine only as well. Thank you, Your Honor.
Thank you.
Are you all today?
And Miss Thornton, you're free to leave, okay?
Okay.
I'll email you a copy as well, okay?
Okay. Have a good day.
Bye now.
Bye-bye. Mr. Featherston, good morning.
Good morning, Your Honor. I believe all parties are here for 9:30 a.m. case ending in 4910.
I believe so. Are you ready for me to call it?
Yes, Your Honor.
Okay. Calling case number 22394910, Latonia Mason versus Tamara Bolden and all occupants.
Gerald Featherston, P 83480 on behalf of Ms. Bolden, who is present.
All right, Ms. Bolden, can you state your name for the record?
Tamara Bolden.
All right, thank you, Ms. Bolden. And Ms. Mason, can you state your name for the record?
Latanya Mason.
Thank you, Ms. Mason. Were parties able to work out some type of resolution in this matter?
No, Your Honor. After I found out about this hearing last week, I had reached out to Ms. Mason to ask for a copy of her motion and a copy of the up-to-date lease so I could discuss with Ms. Bolden, but I have not received that.
All right, Ms. Mason, can you get that copy of what do you need, a lease and what else?
A copy of the motion to reinstate, Your Honor. I don't believe I received one.
Okay. Ms. Mason, can you provide that motion to reinstate?
Yeah,
She has my email, Your Honor. Just send it to that email, Miss Mason.
you don't still have it? I sent it to you before.
I still have it. I sent you an email last week. You should have received it.
No, you don't still have a copy of those? I sent them to you before.
So you sent me a lease, I think in March, and I believe we're now in June. So I need an up-to-date copy of that ledger. And I also need a copy of that motion you filed.
Do you have a copy of the motion, Ms. Mason?
I don't know. I gotta find it.
I have all 3 copies in this file, Attorney Featherston.
So that would probably explain why it was not served with a copy, Your Honor.
Yes, I think that explains it all. And for the way these cases have been going and the court dates, I've been granting the motions, but we're here today. Today is the date and time. Now I know you're defending Ms. Bolden, so I dismiss this case. Okay. I dismiss this case on the plaintiff. All right. So is there any objection to an adjournment, Ms. Mason?
Yes.
How much is currently due right now on this case?
$8,709.50.
I would just like to note for the record, Your Honor, that I don't believe this motion should have been reinstated at this point, as defendant didn't get a notice of it. I understand you might still reinstate it, but I just want to perfect the record.
Okay. And I can get this, I can send this out. I'll wait to make a ruling on it. Let's do it.
What was that, Your Honor?
When can both parties come back? Because we can address I can send a copy of the motion to you, to both sides. You can provide your argument. It shouldn't, it shouldn't be a 21-day, 14-day process. It's a one sentence motion, but you are entitled to it, and you are entitled to sometimes respond. So,
thank you, Your Honor. Could I just get a 10-day adjournment, Your Honor? I think this 7-day adjournment was a little quick for me. I didn't get a lot of time to follow up with my attempts to get copies of the documents I want. I might have had a better time getting it if I would have just had a little bit more time.
Understood.
Your Honor.
This is an attempt to keep it digital, and in the event we can figure it out, not bring all parties to the court. But yes, go ahead, Ms. Mason.
We keep adjourning this. When are we gonna have the case?
Okay, would you all like to have the hearing right now? It's literally a 2-sentence. No, you filed a motion, Ms. Mason, and the other side is entitled to respond to the motion that you filed. So I can't read, this case was dismissed. It's being motioned by you to reinstate it. So the other side is allowed to have their argument for the purpose of whether or not this case should be reinstated. Although it can be refiled, it's dismissed, you can refile it, or we can wait and you argue your motion. But he's entitled to time for the motion, so that's your decision. This is your case. So, but this has been going on for a while, but let's see, today is the first, so 10 days would June 13th work. Or do you need a Monday?
I'm checking, Your Honor. I would prefer yeah, the Monday I would prefer, Your Honor. The
Or
Monday
June
or the Wednesday.
All right, and this is June 12th at 10 a.m.
What was that date again, Your Honor?
Monday, June 12th.
I'm never gonna finish this case.
At 10 a.m. All right, I'll see you all back Monday, June 12th. We'll be in person.
Thank you, Your Honor. And
Correct.
Yes, ma'am.
Miss
Today.
Mason, please send me those documents at your earliest convenience.
I'm sending you the same lease that you already have, and he's gonna send you the other paper. Is that how it's
I
going?
want an up-to-date
Does that
ledger and a
lease-
copy of the motion.
I can't hear you. Say it again, please.
An up-to-date ledger and a copy of the motion, please.
That's the ledger that I have. That's the only ledger that up-to-date ledger. Okay. So you don't need the lease, right?
No, I have your HAP contract already
So just the up-to-date ledger.
and a copy of the motion, please.
He got to send that out to you, right? Isn't that what he's sending out?
I have the white. I don't think she has a copy because I have the white, yellow, and the pink. So I'll get that out to you. I'll make some copies. If you all, yeah, I can't email you from the court computer. I'll send it out. It'll be mailed out today.
All right, thank you, Your Honor.
If you like me to read?
Okay,
Yeah.
so now all you need from me is, what do you need from me?
Up-to-date
Just
ledger.
the lead? Oh,
The
the
ledger.
up-to-date ledger? Okay.
All right, thank you.
You're welcome.
Have a good morning, Your Honor.
All right, you too. Yeah, you all have a great morning. All right, iPhone 2.
Hey, don't get it. I'll cut this shit off.
Are you hired? No, I'm not. Quicker, okay. iPhone 2 with the hand up. Good morning.
Good morning.
All right, it is now 10:15. We have only 10 a.m. cases, and we do have an afternoon docket, but that is not relevant for you all. So, what is your name, sir?
Mark Olaki, case number 23347-229.
47229. You said you're Mr. Lackey?
Yes, sir.
All right, good morning, Mr. Lackey. Are you represented by an attorney? Good morning.
No, sir.
Okay, do you want an attorney or do you want to speak directly to the plaintiff's attorney?
Is it possible, can I split to the plaintiff's attorney?
Okay, yeah, and I believe that's Mr. Horka.
Yes, I'm here, Your Honor.
All right, good morning, Mr. Horka. Well, what we can do, I'll invite you all both into a breakout room. I'm going to give you breakout privileges, Mr. Lackey, so you don't get stuck in the room. I know we can bring you out, but sometimes that happens. All right, so.
Okay.
Room number 8. Let's see. Room number 8. Parker, room number 8. Let me know if you all come up with the resolution. Ma'am with the hand up in the gray shirt, red glasses. Good morning. Oops, I think I just muted you. I'm sorry. Go ahead, unmute again. Good morning. There you go.
Good morning,
Good morning. What's your name?
Tanika Fisher.
Tanika Fisher. I have
Yeah.
you on the docket today. Is Tyrone Kemp here? All right. At 11, I do defaults and dismissals. So if Mr. Kemp doesn't arrive, I'll dismiss it around 11. If he, do you know if your case is going to be dismissed, or do you have a reason to believe that your case is going to be dismissed?
Yes, me and him discussed it about a couple of weeks ago. We came up with a payment arrangement. So we didn't show up to court the first time, but then I received another letter saying that I was going to be in trouble if I didn't show up. So I just decided to show up. And then I have a couple of.
Who did you receive a letter from and told you you're going to be in trouble?
District Court. It's it's a failure of the defendant to appear in civil case may cause a default matter or failure or whatever. So I just said, well, let me just show up. Plus, I have a couple of complaints.
You say you had a couple of changes?
Complaints.
All right. Well, is Mr. Kemp showing up?
I don't think he will. Because like I said, we made a payment arrangement for the money that I owe. So he didn't have to go to court. But when I received the second letter, I was a little nervous.
All right. So at 11 o'clock, just interrupt what I have going on. I mean, don't. Just let me know. Make sure you let it be known at 11, because I call dismissals at 11 or defaults.
So hang up now. Zoom and get back on the Zoom at 11.
Or 10:50 to make sure Mr. Kemp isn't here.
So
that's fair with the court if you come back in at 10:50.
Okay, so hang back in at 10.
Correct. And you don't want legal counsel, correct?
No.
All right. Yeah, you can log back in at 10:50.
Okay.
All right.
All right, thank you.
Well, Ms. Lamonius.
Yes, Your Honor. I wanted to know if someone had checked in for Attorney Cox's office, or if that was Attorney Horka covering for Attorney Cox today.
Good question. Going to. Okay, I know that was planned out there. I could assume, but we could all assume. So, I'm not sure. I'm not sure if I have the answer to that question, Mr. Moniz.
Okay, well, may I have breakout room privileges then?
Oh, absolutely.
Thank you.
All right, Kimberly's iPhone. Did you have a question?
No, I don't have a question. I just got back on here at 10 o'clock.
Okay. I remember your.
For the two cases, and again, 7204 and 5.
Ms. Trumbull.
Yes.
Stasha Sumlin and Asia Harris.
Yes, sir.
Right. Gallery. Lish. Lish doesn't sound like your defendants. Is India Blount here?
Here and speaking with legal aid in a breakout room, Your Honor.
Okay. All right, thank you. See, good morning, Attorney Hoots. I see you. Your defendant is speaking to legal aid, as you may know already. See. All right.
Thank you, Judge.
You're welcome. Mr. Horka.
Judge, I don't have the case number, unfortunately. I'm sorry, but I'm ready on the case with Mr. Lackey. He put us in the breakout room a moment ago.
Calling case number 2334-7229, MBA Management Detroit versus DeMarco Lackey and all occupants.
Good morning, Joe Horka, P75969. I appear for the plaintiff.
Good morning, Judge.
Good morning. Can you state your name?
Del Marco Lackey.
All right. Good morning to both of you all. Were you all able to work something out?
We were, Your Honor. This is a complaint to recover possession, termination action. The parties are agreeing to submit a consent judgment with a June 30th vacate date. Mr. Lackey indicated I had his permission to sign.
June 30th, vacate date. All right. Any questions?
No, sir.
All right. And was MCR 4.201I explained?
I did also explain that to him in the breakout room.
Okay. So for any reason, if you think that this agreement was going about incorrectly, or if you were pressured, or just think it was a bad decision and you decide to file a motion with the court, you have that right within the 3-day period to appeal. And that's within the court rules. So that's what MCR, Michigan Court Rule 4.201I is. So we have to let you know because you're not represented by counsel. So court will enter this. Okay. And the court will enter this consent judgment where Mr. Lackey agrees by June 30th. Good luck, Mr. Lackey. Does Mr. Horka have permission to sign your name on the consent judgment?
Yes, sir.
Okay. All right. Well, good luck, and you are free to go. Mr. Lackey, have a great day. All right. Thank you. Are you doing Attorney Cox's cases today, Mr. Horka?
It was not supposed to be. I can pitch it if I need to. I'm trying to figure out who is supposed to be here though.
Let's keep you focused. Freddie Williams, Jerry McGee, and I think he only has one case with the case with Attorney Lemonius, and that's Catherine Baker. So Attorney Smith. So yeah, looks like you have 2 cases left this morning, Attorney Horka, and then if you're doing Cox, just one more, but got you now, So
Good morning, Your Honor. How are you?
doing well. How are you?
I am doing well. I have 2 questions for you. Do you have case number ending in 7023 on your docket for today? We rescheduled the first hearing.
7023. You rescheduled the first hearing?
Yeah, she had an adjournment to, I think it was May 23rd, or yeah, May 23rd, and we rescheduled it to today with the help of your clerk.
What's the full case number? What is it? What's the full case?
23347023, Rebuild in Detroit versus Salata Collier and all occupants. Mr. Fortuna is on the case as plaintiff's counsel.
Good morning, Your Honor.
Good morning, counsel. Is this awaiting a dismissal?
No, I filed an answer in affirmative defenses. However, I haven't had the chance to talk to Mr. Fortuna this morning.
Okay.
Someone else put this up here, Judge. Hearing on June 1st. He didn't actually put it in the system though.
Say walk to courtroom for judge to review. Did you all walk this in?
Did I walk in the stipulated order to adjourn or the answer in affirmative defenses?
The stipulated order to adjourn. It's irrelevant anyway. Okay, but you are on the docket for today.
Great. So
I will hear this case today.
Okay, thank you. And I see I got privileges too, so I will be back shortly.
Because if it's not today, it's someday. So.
Did you say someday or Sunday?
No, someday.
Okay.
Yeah.
All right.
So, okay, just let me know. Keep me updated.
All right, thank you.
And I'll give you some breakout privileges as well, Mr. Fortuna. Look who has arrived. Now we have 20 minutes. Judge, here's the. Good morning, Mr. Kemp.
Good morning, sir.
All right, Mr. Kemp.
Good morning, sir.
Good morning. Ms. Fisher was here earlier. I told her, I asked her, did she expect for you to come? She said no. I said, I'm not dismissing the case until 11 to allow you time to come. I'm glad I have that policy because you arrived. So, she may either Zoom in about 20 minutes. I told her to come back at 10:50. If you can, or you can give her a call and ask her to Zoom in, and we can maybe speed this up a bit.
Okay.
So it's up to you, but she'll be back at 10:50. But if you need to hop off, call her, and you all come back in, feel free. If you want to call her on another phone, whatever you want to do. She said she'll be back at 10:50. So if you want to call her and bring her back now, we do have time.
Okay.
So.
Okay. All right. Okay.
Because, and Mr. Kemp, let me tell you this too, while we're here. Can you hear me?
Yes, I can hear you.
Okay. There are attorneys for Ms. Fisher here. She didn't say she wanted to speak to an attorney, but she said that you all agreed to a payment arrangement. It may be helpful if you all have an agreement to have an attorney help craft it. But I'll wait until we get on the record, and if the agreement works where I can just make it work, that's fine. And if it doesn't work legally, then I may suggest you all just talking to a legal aid attorney and they can get you through the finish line. So.
Okay.
To consider.
That sounds good.
All right.
Okay.
All right. Attorney Devlin. This is a dismissal. 23347-176.
Your Honor,
Oh, no
Attorney Bradley.
pre-trial for today. Okay.
really quickly, Your Honor, could we just have the phone number for your courtroom?
Phone number for the courtroom.
I already put it in the chat for Miss LaWan.
Ah, okay. Thank you very much.
You are welcome. Thank you. Madam Court Reporter.
Sure.
David Campbell. Attorney Spaniolo.
Good morning, Your Honor. How are you?
Doing well. How are you?
Good, thank you. I've had the pleasure of pre-trying the matter with Brother Counsel Barishaw. Hopefully I didn't butcher his last name, and we're prepared to go on the record if you are.
Okay. I am prepared. Calling case number 23347-180. This is Evernest LLC versus Constella Manier and all occupants.
Good morning, Judge. Thank you. Attorney Paul Spaniolo, P72366 on behalf of the plaintiff in this matter.
And good morning, pardon me. Good morning again, Your Honor. Tom Barishai, P83642 on behalf of Constella Manier. Constella, could you state your name for the record?
Constella Manier.
Good morning, Ms. Manier.
Good morning.
So, Your Honor,
All right.
today's sorry.
Go ahead.
Today's a day and time for a subsequent hearing on this. It appears that now I filed with the case, and it should be in the file, a quitclaim deed from the Wayne County Treasurer, would appear to be a land bank sale, subsequent to a judgment of foreclosure. Now, the judgment of foreclosure I did not provide in your file, Your Honor. I did provide it to Brother Counsel shortly before we came on here. I just give you context. I received a couple calls from Ms. Manier advising of ownership issues and the like. And so I took the liberty, and forgive me for not giving this to the court in anticipation of today, but I took the liberties of going to Wayne County Register of Deeds and doing some preliminary research. So it appeared that there was a quitclaim deed, at least from someone named Sammy and Williams Lizzie back in 2019 to Ms. Manier. And then there was some forfeiture deeds that I sent to Brother Counsel. And then finally a judgment of foreclosure that was recorded on 9/28/22. My client subsequently, that should be in the files, reflected a quitclaim deed dated November 11th, 2022, and it's recorded 11/11/22. It's our position that her rights have been extinguished, and I don't see what the issue of fact is here, but I suspect Brother Counsel will tell you something to the contrary, so I will be quiet at this point.
Thank you, counsel. That's correct, Your Honor. Ms. Manier is contesting both the validity of some of those recorded documents that Attorney Spaniolo has provided, and she believes she has been defrauded. She's asking for a trial to be set, Your Honor, and also she has indicated that she is prepared to retain private counsel as well. And so after this request, I would request that I withdraw from this case so that she can get private counsel.
All right, well, let's
Your Honor, also as to evidence about the competing ownership, Miss Manier is in possession of a warranty deed that was also recorded. It was originally dated in 2019. And so there are issues of fact here that a trial could resolve.
It sounds like both parties agree on her having a valid deed. I think it's from Sonny Lizzie to Miss Manier, that deed is legitimate, and as you stated, could possibly be a warranty deed. The issue is the foreclosure, which led to the sale, which led to new ownership based on what's been presented. So the least we can do is have an evidentiary trial, Ms. Manier, to address the issues.
Okay, that sounds good. I'm sorry.
And because the register of deeds and your attorney will tell you, opposing counsel will tell you, I mean, you're in the chain of title. However, there's a deed from the county to the new plaintiff, Evernest LLC. Well, it's not to the new plaintiff, Evernest LLC. It's to
Curtis Jackson.
Curtis Jackson. And
he went down there and changed my name out of the house.
And Megan Taylor.
He went down there and took my name out of the house. This is my grandfather's house. Sammy Williams was my grandfather. Then they said the house was abandoned. The house was never abandoned. I grew up in this house. My mother just died in this house in February. My grandfather died in this house at the end of 2019. This house was never abandoned, Your Honor. Never. I'm 50 years old. I've been living in this house since I was a kid.
I think it was a misunderstanding because he said it was obtained by the land bank. Stuff from the land bank is usually abandoned, but this is a Wayne County tax auction. So that may have just been misstated by plaintiff's counsel. So I'm sorry for your loss. So this is what we're gonna do. We just set an evidentiary hearing. You bring your proofs, Ms. Manier. You bring your attorney. If you have an attorney, make sure he calls Mr. Spaniolo before the hearing date. I'm not gonna out too far because whatever the proofs are, we just need to get to it so we can have a resolution. All right.
Okay, sounds great.
We'll be back in person. How much time do you need?
I have to call Mr. Blake. I could call him today, but you know he's a very busy attorney. So can you give me like, what's the longest you can give me?
Is this right, Blake?
Yes, Willie Wright Blake.
Okay, and I can always set a date, and because I'm not going to determine title. We're just going to be back here arguing whose deed is the best, really, or presenting evidence of the chain of title, essentially. And if a determination can be made, then a determination can be made that day. So I'm going to, let's leave it within 2 weeks. That will put us at June 15th. June 15th, let's prepare for June 15th. Go ahead.
Your Honor.
Yeah.
I'm in, what time would that be at?
What day do you need, counsel?
If court is amenable and Ms. Manier, June 16th would be ideal, or the 14th.
The 14th rather than the 16th.
Oh, the 14th is better? Okay, that's fine.
Well, the 14th, my son graduates. That's not gonna be a good day.
We're not gonna do that then. Congratulations. We can do the 16th.
Thank you. I appreciate everyone's understanding.
No problem. June 16th at 10 a.m.
Okay, thank you. Everybody have a good day.
Thank you, Judge.
Good luck, Ms. Manier.
Oh.
Manier, we'll be in person on the 16th, okay?
In person. Okay, what's your courtroom number?
I'm 436. And I'm Judge Adam Sabree.
Okay, gotcha. Thank you so much. I appreciate everybody.
All right, you have a great day.
Your Honor, should I draft and submit a withdrawal order?
And Ms. Manir, is there any objection to Mr. Barakshai withdrawing from this matter?
No.
Okay, counsel?
Do we have a contact? Do we have a contact number for Mr. Blake?
Yes, it's in my phone. Need it?
Yes, if you don't mind texting it to me or calling me with it, that'd be great.
Sure. And
yeah, I mean,
what's your
I'm not
phone
gonna
number?
wait for him
I don't
to
have
call
your
me.
number.
My
I
phone
don't have
number's
your
on the
number.
pleadings. You called me twice, Ms. Manir.
Oh, okay.
All right.
Okay.
Okay.
I'll send it to you.
Thank you.
Mr. Barakshai is withdrawn from this case. You don't have to file a motion to withdraw. It's the oral motion is granted. Ms. Manir, it was upon Ms. Manir's request because she's going to retain private counsel for the extension of this, to the extent of this matter. So thank you, Mr. Barakshai. You are free from this matter, and I'll see you all back on June 16th.
Okay,
Thank you, Your Honor.
Judge. Have a great weekend, everyone.
You too.
Good luck, Ms. Manir.
Thank you.
Attorney who?
Thank you, Judge. Last digits for the case, 123.
Calling case number 2334723. This is Queen Lillian 2 LLC versus Danielle Ruffin.
Thank you, Your Honor, and good morning. Paul Hughes, P31986, appearing on behalf of the plaintiff.
Good morning. Sorry about that, Your Honor. Good morning. Tom Barakshai, P83642 on behalf of the defendant, Jerry Ruffin, who is an occupant. Mr. Ruffin's not here this morning, but he's given me authorization to resolve the matter.
Thank you, Your Honor. We've agreed to propose a hearing judgment, convert the non-payment to a termination case against all occupants with a move date of 6/16 or a writ to issue.
All right, this case was originally a non-payment of rent case. This will be converted to a termination of tenancy case, whereas and named parties will be removed, whereas all occupants must vacate by June 16, 2023, or a writ of eviction may issue. All right.
Thank you, Judge. Thank you, Tom.
Thank you.
Thank you, Thank you. It's Hannah Fawkes here. Oh, Hannah Smith is here.
Ms. Collier, can you please tap the prompt I sent you to go into a breakout room? Sorry, I was just cutting in line. That's why I raised my hand.
Sorry, you raised your hand, so.
I didn't see the prompt.
Okay, let me send you another one.
Thank you.
Mhm.
Ms. Collier. 212. On a breakout room.
Is Stasha Sumlin here? Looks like she's got it.
Did you say, Your Honor, Sasha?
Stasha Sumlin?
Yeah, she's in a breakout room. I just did her intake. She's with an attorney. She was with an attorney not long ago. So she's in there.
Okay, thank you. Did you hear that? What I'll do for you. Where's Ms. Trump? Okay, Ms. Trump. Trimble's in the breakout rooms as well. Okay. All right. Is Ulysses Barnes here?
Yes, yes, sir.
All right. Good morning.
Good morning.
All right. And is Attorney Mosca or anyone representing TEGRF here?
I'll stand in. Can I get the case number, please?
23347220.
Okay, I'll take a look.
Okay. All right, Mr. Barnes, do you have an attorney?
No, sir.
Are you looking to be represented by one?
Yes.
Is there attorneys available? Is this a commercial or residential property? Is this
Residential
okay.
apartment.
Gotcha. All right, this is what we can do. I can invite you into a breakout room. I'll invite you into the UCHC lobby. You should see an invite, and someone may be in there to speak to you. They may do an intake, see if you qualify, and then they may choose to represent you or not represent you. And then, Mr. Hark, are you taking that case on?
I will. I had marked this as a default back on May 26th, so I guess he must have appeared later.
Were you originally defaulted?
Yes, that's what I had noted back at the last court hearing. But I can stand in now and try and resolve it.
Okay, he requested legal counsel, so I invited him to the UCHC lobby. It's up to you, Mr. Harkin. Either way you want it. It's all right.
Okay, I'll stand by and wait for him to talk to legal.
Okay, all right. Is Freddie Williams here? Is Jerry McGee here? No Freddie Williams, no Jerry McGee. Stasha Sumlin is in room 4. Kimberly Trimble is in room 5. Mr. Fortuna is in room 9. Mr. Fortuna. No. India Blau is in room 11. This might be a good time to take a quick break. We'll take a 10-minute break. Madam Court Reporter, let's come back at 11. No need to log off if you're on, but we're going to step away for 10 minutes and then we'll come back and finish up that. And Madam Court Reporter, don't work. I'll check her in. Take your 10-minute break. Okay. Yeah, I'll facilitate this. Good morning again.
Good morning. Is that me?
Let's see. Ms. Fisher, correct?
Yes.
We'll be back on record at 11. 11, all right. Fisher 167. All right, I'm going to give you both co-host privileges. All right, that means you can move in and out of the break rooms without having any issues. All right, so I'm going to invite you all both into a breakout room. work something out, and then I'll call your case when you're ready. If you need some assistance, well, yeah, I'll call your case. You all have a conversation, and I'll call your case at 11 when we go back on the record. Okay. I'm going to invite both of you all into a breakout room to speak, and then I'll call your case at 11.
Okay.
I think it may be helpful. Yeah. If you all have an agreement, you have an agreement, but it may be helpful for an attorney to step in. But we'll see at 11. I let my court reporter take a 10-minute break, so we can't put anything on the record. So if you all want to speak, I'll invite you into a breakout room. You think it's necessary? Go for it.
It's not necessary.
Okay. All right. So we'll call it at 11.
So am I hanging up and coming back?
No. Just gonna sit tight.
Okay.
Just give a reporter a break, and most parties are in the breakout rooms trying to negotiate cases. So if we weren't on break, I'll call it right now. But I'll just call it when we get off break.
Okay.
All right. So you all sit tight, and I'll see you back in 8 minutes.
Okay.
All right. Okay. Let's see, Madam Court Reporter.
I'm here, Your Honor.
Okay. So Attorney Smith, do you have something that is ready?
Yes, Your Honor, we are requesting an adjournment for, what number was it? 023.
Is this the case number that was, that we just located?
Yes.
Okay, calling case number 23347-023. Could I have parties appearances?
Good morning, Your Honor. Patrick Fortuna appearing on behalf of the plaintiff, Rebuild in Detroit LLP. My P number is P81281.
Good morning, Your Honor. Hannah Smith, P86433, Lakeshore Legal Aid, on behalf of defendant Ms. Collier, who is present in the Zoom gallery. Ms. Collier, can you please state your name for the court's record?
Salada Collier.
Thank you. Your Honor, we are stipulating to a good cause adjournment to hopefully work things out in the meantime. If the court has the morning of June 13th open, I think that would work best for all parties.
June 13th is available. I know I'm gonna have my first hearings at 8:30, second hearings at 9:30. So let's do 9 o'clock a.m.
Thank you so much, Your Honor.
You are welcome. That's 23347-023. All right, I'll see you all back June 13th.
Thank you so much.
You're welcome.
All right, Ms. Collier, I'm going to bring you into a breakout room again, and then you're good to go.
Okay.
Have a good day, Mr. Fortuna.
Have a good day.
Well. Thank you.
Okay, calling case number. Right. All right, calling case number 2334-7167. This is Tyrone Kemp versus Tanika Fisher. All right, let's see, I see Tyrone Kemp is here. Mr. Kemp, can you state your name for the record?
Tyrone Kemp.
Thank you. And Ms. Fisher, can you state your name as well?
Tanika Fisher.
All right, let me locate this file. 7167. All right, today we're here for a complaint to recover possession of property. Okay. Have parties worked out some type of arrangement?
Well, Your Honor, we did speak, and the defendant is planning to move. She's just going to move, and we're going to move forward that way.
Okay, when do you plan on vacating, Ms. Fisher?
Say that again.
When do you plan on moving?
I need a little time just to, find my place and get out.
Okay, and how much time?
I guess like a month or two.
Okay, is there any objection to a 45-day move out, Mr. Kemp?
No objection at all, Your Honor. She's been a great tenant. She's been cooperative. That wouldn't be an issue for me at all.
Okay, so is there any objection to a judgment in all occupants and removing Ms. Fisher as a named party?
No.
No objections.
Okay, all right, it's totally up to you. This is your case. So you said no objection, and and will have the same effect. So, all occupants must, I'm gonna do a judgment by hearing where all occupants must vacate by July 14th, 2023. And July 14th is a Friday. So the earliest you could apply for an eviction would be July 17th. And obviously, if you all work something out in the interim, get it in writing, but we won't be coming back to court. So this way, you have a judgment, Mr. Kemp. If Ms. Fisher decides to, if she doesn't move out by the 14th or by that upcoming Monday, then you have a legal right to come in and apply for a writ of eviction. If she does move out, then you have your property back and parties move on. And a judgment will be entered today in all occupants. So Ms. Fisher, if you're looking for more housing, you have a better shot without the judgment in your neck.
Okay.
Any questions?
No questions, Your Honor. Thank you.
Now, Mr. Kemp, will you be sending in, this is technically a judgment by hearing. I know both parties are unrepresented. So the court will enter this judgment by hearing and we'll send out copies to both sides. All right?
Okay, thank you, Your Honor.
You're welcome. All right, thank you, Ms. Fisher. Thank you for coming back on time. Mr. Kemp did show up, so you all worked it out and you all have a great day.
You too, thank you.
Make sure you coordinate with the move out so he has his keys and the property's not left open to the elements, new visitors.
Okay.
All right. All right, take care.
You too. Bye.
Thank you. All right, Mr. Kemp, you're free to go. You all get a copy in the mail. Ms. Fisher, good morning.
Good morning, Your Honor. How are you?
I am doing well. How are you doing?
I'm doing well too. Thanks for asking.
Do you have a case that's ready?
Yes, I do.
And what is that case number?
The last four numbers are 7204, and the case name is Stasha Sumlin.
Okay. Calling case number 2334-7204, Kimberly Trimble versus Stasha Sumlin. And all right.
Your Honor, the landlord should be present. Her name is Kim Trimble.
I'm here.
Yeah. Can you state your name, please?
This is Kim Trimble.
Thank you.
Janetta Fisher, P72872, with Michigan Legal Services, representing Stasha Sumlin. Please state your name for the record, Ms. Sumlin.
Aisha Sumlin.
Your Honor, we can't reach a resolution today. I need to get some documentation, namely a number of different ledgers from the landlord. The landlord said she could have it to me no later than tomorrow. So we're asking for a 1 week adjournment. Can we come back next Thursday, which is June the 8th?
That seems appropriate. That seems doable. Let's see. June 8th at 9 a.m.
Thank you, Your Honor.
You are welcome. And are you representing Ms. Harris? Okay, that concludes this matter ending in 7204, Kimberly Trimble and Stasha Sumlin. Ms. Trimble, will you be able to make it June 8th?
Yes, I will be. We'll be in your courtroom then, right?
That is correct.
Oh,
Courtroom
right.
436.
436.
Yes, and there's a
No problem.
Sabree in 438, but that's, you'll know when you walk in there, you entered the wrong place.
All right,
So,
not a problem.
Okay. So
436.
Stasha, okay, Stasha, we're going to be in person. Okay. All right. Okay. So see you then.
Back and allow time for parking and for parking and getting through security. You can bring your phones in now. I'm not sure about earpods, but telephones you can bring in the court now. So I won't default. I'll wait an hour before I default, but just keep that in mind because it is much longer than logging on to Zoom. So it may go by faster. So I'll see you and you're free to go.
Okay, thank you.
So, calling case number 23347205. This is Kimberly Trimble versus Asia Harris. It's Asia Harris here.
This is Kim Trimble. I'm here.
All right, Asia Harris. Is there anyone named Asia Harris who is present in this courtroom? And Ms. Trimble, did you have proof of serve? Did you have this case served?
Yes, I did. I dropped everything off down there on the second floor.
Okay.
Carlton Carter with the 36th District Court served it.
All right. And was it served by, do you know, do you have it handy?
I didn't hear you, Your Honor.
Okay, I see it. I see it in the ROA is served. So
okay.
Court is satisfied with that. Does anyone live at 15763 Ardmore? Court doesn't hear anyone who is responding to Asia Harris or that address. This is a complaint for non-payment of rent. How much rent is currently owed?
For that one, $8,300, Your Honor.
All right, does that include court costs?
No, it did not. And it doesn't, well, you know, it's June now, but when we put it in, it was $8,300.
No, what is it now?
It will be another $875 for June.
Okay, so it's 5, 7, 1, 9175.
Yeah. Okay, will we put this in? I was trying to see if we put this in before May, because she would need to pay for May too, but
This was filed. This was timestamped. Okay, this was filed in May. No, this was filed in April. It was signed by the clerk.
April, right? So we would need to add May in as well. I apologize.
So rent is $875.
Yes, sir.
So that's $1,750. 875 times 2 is $1,750, right?
Yes, sir.
Plus 8,300.
Yes, sir.
10,050.
Yes, sir.
All right, and filing fee is $55. And how much did you pay for your process server?
It was $30, sir.
Added 10, 0, 10,135. $10,135. $10,135 must be paid or defendant must vacate. By, and are you requesting the statutory 10 days?
If that's the shortest, Your Honor.
June 1st, so it'd be June 12th. 2023. Defendant must pay or vacate by June 2023. Default judgment is entered. Are you requesting a default judgment, counsel? I mean, Ms. Trumbull?
Yes, please.
Our default judgment is granted and defendant must pay or vacate by June 2023. The amount to redeem is $10,135. Satisfy the judgment. And that is case number ending in 7205. So I think you have one turn. You're welcome. You'll be back in a week. And then this one taken care of. That concludes your caseload, right?
So I do have a question, Your Honor. If she doesn't vacate by June 13th, do I have to come down there and get a writ, or do I just go ahead and send the bailiff?
No, you still have to apply for a writ, and you also
Writ,
have
right?
you also have to submit that judgment to the court so we can sign it. The judgment from today. So
Not a problem.
make sure. Did you write the numbers down?
No, please give them to me.
All right. The amount due was it 10,135.
Oh, I have that. I do have that. I have that. Yes.
10,135 by June 11th, 2023.
Yep, I have that.
Mark the judgment as a default.
Okay.
All right.
Thank you so much.
You're welcome, and make sure you send that in to the court.
Will do. Thank you.
Attorney Albu.
Your Honor, good morning. I think I have a default on 7129.
Calling case number 23347-129. This is Federal National Mortgage versus Portia Bowen and all occupants.
Morella Albu, P67035 for the plaintiff.
All right, does anyone live on Pinehurst? 16629 Pinehurst. Is Portia Bowen here? All right, defendant failed to appear at the first hearing and has failed to appear again today. Counsel, how would you like to proceed?
Your Honor, I am seeking a default judgment of possession at this time.
All right, default judgment is granted. Defendant must vacate by June 12th or a writ of eviction may issue.
Thank you, Your Honor.
You are welcome. Have a great day.
You too.
Is Attorney Devlin here? All right, let me see. All right, Attorney Devlin, I'm ready for you.
Yes, Your Honor.
Calling case number 23347176. This is north of Kirchable LLC versus all occupants at 3065 Parker Street.
Your Honor, Adam Devlin, P 72877, here on behalf of the plaintiff. And I'm sorry, you said this was for 178?
176. This is 23347176, and it's all occupants located at 3065 Parker Street.
So, yes, I'm right. Your Honor, Adam Devlin, P 72877 for the plaintiff.
Thank you. It doesn't appear that the occupant is present. However, counsel, this case was heard in front of me last week.
Yes, Your Honor, it was heard. I had a notice to appear, or I appeared on the 25th before you. A tenant appeared at the same time in the afternoon for the morning. It was except for the morning docket. The occupant talked with Attorney Braley, and we realized that there was an application of an amended complaint on another file applied to this case. And so we agreed to a June 26th move out date for the occupant in 176, as well as we'll call it an unamended complaint back to the original address. This property's original address was 3053 Seaburn, which is where it was served.
Understood. So in this matter, consent judgment was entered and signed by both parties, you as well as Kylie Ragland.
It was signed by Ms. Braley.
Okay, Ms. Braley on behalf of her client. All right. Well, thank you for your appearance and putting that on the record.
No problem, Your Honor. What the odd part is that the true 3065 Parker was heard today before Judge Sherman.
Okay, so this
is 3053 Seaburn.
3053 Seaburn, that was amended. Okay, yep.
It was amended away and then amended back.
Exactly, which is why the notice says 3065. I got you.
Yes, Your Honor. But
All
things
right,
were served originally at the proper address.
Okay, yeah, I do remember that. So not an issue. I do have proof of service in the file. So
Thank you, Your Honor. Have a good day.
You have a great day. You too. Good morning. Still morning. Okay. So you're here in person for Ajmi?
Yeah, I need to pick up.
Oh, I got you.
Yeah.
Called you the
Okay, stop video. Looking for.
Is Freddie Williams here? Freddie Williams. You ready for me, Attorney Horton? Jerry McGee here. Mr. Horton, ready for these defaults? Are parties ready on Blount? So with these writs,
Your Honor, I would like to ask for a dismissal in a 10 o'clock matter.
all right. What is this case number ending in 7220?
It's a Catherine Baker. That is, yes, that's 6705.
Okay. Are you sure Mr. Hork is not representing investors' properties?
I chatted with Mr. Horka a couple of hours ago, and he wasn't sure if he was representing them. I haven't heard anything back. I reached out to Attorney Cox's office several times, and I haven't heard anything back from them either. I did hear from Attorney Cox's office a couple of days ago that the client was asking for a dismissal, and I've not been able to get follow-up.
Calling case number 23346705, investors' property management versus Catherine Baker.
Lauren Lamonius, P83053 for Ms. Baker.
All right.
Your Honor, I would ask that this case be dismissed at this time for failures, for plaintiff's failure to appear.
All right, I'll grant you this dismissal, Mr. Monius. There's no one to object to the dismissal. I'll grant it without prejudice and just submit something to the court to decide.
Okay. Thank you so much.
You're welcome. Attorney Hughes.
Hey, Judge, I'm just waiting for Ms. Luan to speak with her client and come back. I think we may have a deal, but we'll see. That's on page number 527.
What about 122, Hannah Falks? Want to call that?
Yeah, that's dismissal, but yes, you can call that one.
Okay, calling case number 23347122, Queen Lillian 2 LLC versus Hannah Falks.
Thank you, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff. We would move that this case be voluntarily dismissed without prejudice at plaintiff's request. The dismissal has been filed with the court.
All right, this case is, I will grant that request, counsel.
Thank you, Judge.
You are welcome. Attorney Fisher, were you attempting to get the court's attention?
Excuse me, Your Honor. This is Lonnie Ward. I was kicked out. Can I please get my privileges back?
Absolutely.
Thank you.
All right, we're, okay.
Thanks.
You're welcome. So, that's right. Mr. Horka, you can take it back if you want.
Did we do the land out of default, Your Honor?
That's good. I'm ready. Calling case number 23347230, NBA Management Detroit versus Freddie Williams and all occupants.
Good morning, Joe Horka, P75969, appearing for the plaintiff.
Thank you. Is Freddie Williams here? Is anyone on at 11255 Charlemagne Avenue? All right, no one has appeared, and it doesn't look like anyone showed up for the last hearing. Are you requesting a default judgment?
Yes, Your Honor. Termination case, just looking for a move out date.
That move out date is June 12th, 2023. Termination of tenancy, defendant must vacate by June 12th, 2023, or a writ of eviction can be filed after that date. Calling case number 2334-7231, NBA Management Detroit versus Jerry McGee.
Good morning, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Jerry McGee, are you here? Proof of service. However, defendant failed to appear on and the second hearing. Are you requesting a default?
Yes, please, Your Honor.
Notice of quit for demand for possession. Default judgment is granted. Defendant must vacate by June 12th, 2023, or written can issue out.
Thanks.
Welcome. All right. Are you done? More.
Judge, we got a deal.
So you struck a deal, huh?
Yeah, 527. What, we were chatting about how to make this world more efficient.
Meanwhile, okay, and before you leave, I have a question about two writs. I don't know. You can answer it, but
Yeah.
still have it. Okay. Let's see. 7520.
This is 527, I think, is what we're looking for. Fairview versus one.
Calling case number. Calling case number 23347527 Fairview Manor Apartments versus Indian Blount and all occupants.
Thank you, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
Suzanne Stepich-Lawan, P48702, Michigan Legal Services, appearing on behalf of defendant Indian Blount, who is with us in the courtroom. Can you please unmute and state your name for the record?
How you doing, Your Honor? This is Indian.
Good morning. Well, good afternoon, Ms. Blount.
Thank you, Your Honor. We've come to an arrangement that we would hope to enter either as a consent or a hearing judgment, whatever your pleasure is. The amount of rent due is $7,711, $162 in court costs, for a total amount due of $7,873. This would be an occupant judgment. The named defendant would not be included. They would have a pay or move out date of July 5th, 2023. If the defendant pays and or moves or turns in the keys, the parties will cooperate in setting aside the judgment and dismissing the case. Ms. Luan, did I cover it?
You did. We also have the agreement that we will clarify and make sure the ledger is correct. So that was the deal.
Yes, and we will cooperate and review any information that they may have. Ms.
Okay,
Luan,
let's do it as a consent judgment.
Okay.
But with the same terms. Okay, so 7873, pay or vacate by July 5th. And in the event that the money is paid or you were to vacate before July 5th, then a dismissal or set aside would occur where this would be removed from your record. You are
Well,
welcome.
and if a judgment enters, it will be against all occupants. So the
That's
named
correct.
defendant will be removed anyway.
Yes.
All right. Good luck, Ms. Blount.
Thank you. Good luck, Ms. Blunt. Thank you, Suzanne.
Thank you. And Indian, I will send you an email later today and then we can talk maybe tomorrow. Okay, have a good day.
And counsel, can you just check on these? I don't need your answer right now, but I have two pending writs and they're a little dated. So I want to make sure, well, no, this is the issue. I see that some money was received and I just want to know if they were satisfied.
Usually I'll put, if there was money received, there would be a partial payment, and I normally check on the judgments that partial payment will not stay the issuance of the writ, but I identify what was paid. It wasn't a separate deal or arrangement. It was just paid pursuant to the judgment.
Okay. Because I mean, because it's a possibility. I don't see a need to have a writ hearing for these cases if I can prevent them.
I appreciate it. Thank you.
So can you just check the case number and see if you all still want the writ?
Give me the case number.
It's 2334-4779.
And you know the parties' names?
It's Dynasty One Detroit versus Roger Gates.
Okay. Do you want me to contact you after I call the landlord to make sure they still want it?
Yeah,
Or do you want me to
please.
call him right now?
You can just call him whenever. I have it sitting here. I'm signing everything else. I just had to post it on that and I was waiting to see you.
Yeah, I think Roger Gates is one that they do want, as of last week. I think he's still there, but I'll check with the landlord and I'll leave a message with your clerk. If you don't, why don't we leave it this way? If you don't hear from me today, assume that we still need the writ.
Okay, that sounds good.
Thank you, Judge.
You are welcome. Thank you. Is Attorney Mosca or someone here for TEGRF Owner LLC? Is Ulysses Barnes here? Ulysses Barnes.
He's in a breakout room. He has saw an attorney, so should be out probably soon.
Who's the other side?
Oh, he's out here now. Yeah, he's out here now. The other side is TEG RF Owner LLC.
Yeah. Calling case number 2334-7220, TGRF Owner LLC versus Ulysses Barnes.
Good afternoon, Joe Horka, P75969, standing for Aaron Cox, the plaintiff.
Good afternoon, Your Honor. Janetta Fisher with Michigan Legal Services, P72872, representing Ulysses Barnes. Mr. Barnes, please state your name for the record.
Ulysses Ricky Barnes.
All right, thank you, Mr. Barnes. All right, okay, this is Attorney Cox's case. All right, have you all had an opportunity to speak?
Yes,
Okay, are you ready to proceed?
I believe we are, Your Honor.
Yes, we are, Your Honor.
My understanding is we're going to enter into a conditional dismissal with box 4B checked. Total due, including June base rent, is $9,726.54. Ms. Fisher and Mr. Barnes are aware that there may be about somewhere between $75 and $100 in other lease charges that pick up related to gas, utilities, those types of things, but we're not including that figure because we don't have the exact amount for June. So again, just the base rent for June, including the balance, is $9,726.54 to be paid on or before June 30th.
Before June 30th, right?
Right.
Yes, Your Honor.
All right, and 4B is checked. Sure, counsel informed you. We don't have to come back to court, Mr. Barnes. If you pay the amount, is it pay or vacate by June 30th, and a dismissal will be entered. But in the event that you don't, a judgment and a writ of eviction could enter it like simultaneously without us coming back to court.
Understood.
Okay, and do you give your attorney, Ms. Fisher, permission to sign your name?
Yes.
All right, court is satisfied. Did I miss anything, counselors?
No, Your Honor.
No, Your Honor.
All right, good luck, Mr. Barnes.
Okay, thank you, sir. Have a good one.
You too.
Thank you, Your Honor. Ulysses, you can leave.
Mr. Barnes.
Yes.
This is not related to your eviction, but I see your address. Is it a lot of traffic? Can you see the Grand Prix from the riverfront? Is it going past? Never mind. Looks like it froze. Screen freeze. All right, never mind. All right. I think that we're done for the morning docket. If I'm not mistaken.
Yep. Yeah.
That's a record.
Yeah, it is a record. I didn't want to jinx it, but we were moving at a pretty good pace this morning. We had our 9s done, our 901s, our 930s, and we only had 10s. Did we do 6142? Leonard Martin.
Six and two.
I believe we did.
Conditional dismissal.
Okay. Yeah, I think we're done with the morning. unless I missed something. So I'll see you all back at 1:30.
Sounds good.
God willing, and the internet stay working over here.
God willing.
599, we get this.
Good afternoon, iPhone. Okay.
Mr. Barnes, you're free to go now.
Okay, thank you. Okay, have a good one.
Have a great one. Have a great day. Good afternoon, everyone. This is Judge Adam Sabree's courtroom. I'm Judge Adam Sabree. This is the afternoon docket. There are no cases that boiled over from the morning. Attorney Landau has a majority of this docket, and Mr. Worker will be representing and standing in for Attorney Landau. There are several cases listed as all occupants, so make sure you listen up for addresses. Let's get started. Is Kenja Kelly here?
Yes, I'm here.
Yes, I am, Ms. Braley. Pretty warm in here.
Yeah, that's fair. It's pretty warm over here.
It's hot today. It's not freezing hot. I mean, it's not super hot. It's also a little bit more comfortable. Let's see. It's Jatana Stewart here. Ms. Stewart, how you doing? Good morning.
Good morning. Good afternoon. How are you?
Doing well. Ms. Stewart, do you have legal counsel?
No.
Are you requesting to speak to an attorney today? Or do you want to speak? Okay. All right, I'm going to invite you into a breakout room. Mr. Horka is the attorney for the landlord. I'll invite you to a breakout room with UCHC and Michigan Legal Services, and hopefully a resolution can be worked out. Do you know what your situation is currently?
I believe so, yes.
Okay. All right.
Thank you.
Welcome. Jason Williams here.
Right here,
Jason Williams. Oh, okay.
I came over here.
Oh, that's you? All right.
And I'm representing him, Your Honor. Is he actually in the courtroom with you?
He's in the courtroom with me.
Oh, okay. Well, that works.
Did you all have it worked out?
I just sent him an email.
I'm sorry.
Go check your email.
Okay, I've got it.
All right. I won't default you.
Very helpful, Your Honor. Thank you.
You're welcome. Is Laverne Bolden here?
Also, Your Honor, may I have co-host?
Okay, yeah, if anyone needs co-host privileges, just pop your hand up. Laverne Bolden is not here. Okay, Ms. Braley is representing Mr. Williams. Tasia Murray. Tasia Murray. Is Tasia Murray here? Let's see who's that. Mr. O'Reilly is here for Attorney Cox. Good morning, good afternoon.
Good afternoon. How are you?
Doing well. How are you?
Very good. Very good.
Tamika Robinson here. Tamika Robinson.
It looks like she's in breakout room 5 with Attorney Barishai, Your Honor.
Okay. Good, good, good. All right. I'll keep signing documents. We don't have that many cases. Oh, I can call some addresses. Let's call these addresses. All occupants cases. And Miss Kelly.
Yes.
Good morning. Are you represented by the attorney? I mean, good afternoon. I'm sorry.
Good afternoon.
Do you have an attorney?
No.
Are you requesting one, or do you want to speak directly with the landlord's attorney?
I guess I could request one.
Right, I'll invite you into the breakout room and someone will be with you.
Okay, thank you.
You're welcome. Two, three, three. You see that invite? Just click join room. Is anyone here from 18307 LaSure? 18307 LaSure.
And they're being represented by Attorney Berishai. We have a resolution.
Okay, that's for 233.
Yes.
Okay, and let's see. We need Attorney Berishai. I'll just mark it, and when he's here, we'll call it. Thank you, Mr. Horka. Is anyone here from 20450 Sorrento? Sorrento, 20450. What about 17552 Ferguson? Bird. What about 8634 Burke Road? Let's try 15828 Belden.
It's a dismissal, duplicate.
Right. On case number 23347237, NBA Management Detroit versus all occupants.
Good afternoon, Joe Horka representing the plaintiff, P75969, moving to dismiss.
All right, this matter is dismissed without prejudice. Thank you, Mr. Horton. All right, call all the names and just keep an eye on who comes in. I'll defaults at 2:30. If there are any, pop a hand up when you're ready. I will be here.
And Your Honor, if Mr. Horka is available, I believe we are ready on the matter with Mr. Williams.
Just need a minute, Attorney Bailey.
I suppose.
Mr. Horka.
Yes, I believe Miss Braley had one ready, if she's still ready.
Okay. All right, calling case number 2334-7240. This is Max Axland, ILDHALP versus Jason Williams and all occupants.
Afternoon, Joe Horka, P75969 on behalf of the plaintiff.
And this is Hillary Braley, P number 82889, here on behalf of Mr. Williams, who I believe is in the courtroom with Your Honor, if he wants to state his name for the record.
Can you state your name for the record?
Jason Williams.
All right, Mr. Williams. Were parties able to work out some type of resolution on this?
No, Your Honor.
Okay.
We're pretty close. I think we'll have it resolved today, but at this point, I think we're asking for two different dates for a move out. I'm asking the court to grant until July 17th. I believe Mr. Horka only has the authority to grant until July 3rd, if I heard that correctly.
That's true, Judge. Without any payments on the account, I only have authority really till the end of this month, but I was trying in settlement negotiations to kick it out a little bit longer, see if we could get it done. It still won't. So I would ask the court to enter a judgment of possession July 3rd.
Okay. How much time do you need, Mr. Williams?
I'll say till July 3rd.
I mean, is that, no, that's, what do you need?
I'm gonna say July 17th.
And I would say, I believe that Mr. Williams had reasons for withholding the rent. I'm not sure that we necessarily need to get into all of them at the moment, since we're just talking about a move out date anyway. But yeah, that's why we're respectfully asking for July 17th. Or 16th. 16th or 17th. 17th, sorry about that. The 17th is a Monday.
Okay. Let's do July 7th.
July 7th, you said?
What's today? Today, May, so July 7th, that'll get you to July 10th.
That'll work.
Okay, all right.
It can be against all occupants, Your Honor, but I would ask for a judgment by way of hearing.
Okay. Judgment by hearing. All occupants must vacate by July 7th, 2023. That is a Friday. Holiday, I think, but the court doesn't take it off. All right. Okay, any questions? Okay, all right, well, according to this judgment by hearing, where all occupants must vacate by July 7th, 2023. Or writ of eviction shall issue. So named defendant is, this judgment is being all occupants. Cool.
Okay,
All right, thank you.
thank you very much.
Thanks a lot,
You
Nick.
are welcome. You are welcome, Mr.
And
Williams.
Mr. Williams, if you need to, you can reach me by email.
Okay.
Cool, okay, thank you. Thank you, Mr. Horka. Thank you, Your Honor.
You're welcome. All right, does anyone else, Mr. Barrett, Attorney Barrett, do you have a matter with Mr. Okay, are you ready on 7233?
I believe we are, if Attorney Horka is.
Yes.
Calling case number 2334-7233. This is MBA Management Detroit versus all occupants.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
And good afternoon, Your Honor. Tom Barishai, P83642 on behalf of Leonard Carter, who is an occupant. I don't believe Mr. Carter is with us in court this afternoon.
Okay. All right. What resolution did we come up with? Did parties come up with?
Your Honor, this will be a judgment by hearing. The case is a termination of tenancy case. It is currently filed against all occupants. And the occupants are to vacate by June 30th.
That's correct, Your Honor.
All right, judgment by hearing, all occupants must vacate by June 30th, 2023. This was in all occupants, so it'll remain in all occupants. All right, that's the final judgment.
Thank you, Your Honor.
Thank you. You are welcome.
Joe, whenever you get around to that, could you forward me a copy?
Yes.
Thank you.
Your Honor, this is Attorney Bonds. Would you give me co-host privileges as well?
You have them already.
Thank
you. Are welcome. It's 2:30 yet. No, it's not 2:30 yet. Have any more action for me, Mr. Horka?
I didn't quite hear the inventory when you're checking people in. I know Miss Kelly is here.
Miss
I don't know
Kelly
if
is,
you.
I think, yeah, Miss Kelly is the only person, and Jatana Stewart, she's here.
Happy to meet with either of them if they're not meeting with legal, but otherwise I'll wait around.
Yeah, they're meeting with legal, so.
Joe, I'll talk to you after I talk to them.
Okay.
And Mr. O'Reilly, you have Tasia Murray. I call defaults, and you have Tamika. Are you already on Tamika Robinson?
Tamika Robbins is the only one I have. I think maybe there's 3 of us in there from our office for whatever reason in your courtroom this morning or this afternoon. But anyway, yes, I'm ready on Robinson. She's being represented by Mr. Barashai and we're ready to go.
Okay. All right.
It's 7248.
Calling case number 2334-7248. This is Logical PM versus Tamika Robinson and all that.
Good afternoon, Your Honor. For the record, Pat O'Reilly for plaintiff.
And good afternoon again, Your Honor. Tom Barashai, P83642 on behalf of Tamika Robinson. Tamika, could you state your name for the record?
Tamika Robinson.
All right, thank you, Ms. Robinson. Good afternoon.
Good afternoon.
Okay, parties, who would like to put, what resolution did you?
Your Honor, I spoke with counsel. We're going to ask Your Honor for a short adjournment to allow time for us to discuss possible resolution. We're hoping in the neighborhood of 14 days.
Right, sounds like 2 weeks. We're on the 1st of the month. Does the 15th work?
15th works perfectly for me, Your Honor.
Works good for me, Your Honor.
June 15th. I know I'll have 8:30s and 9:30s. So let's do 9 o'clock.
9 a.m. Very good.
9 a.m. Ms. Robinson will be in person for this hearing. Everything is in person Monday. So just take into account for time to park or get through here. Shouldn't take too long. Traffic still isn't important. We don't have a full house yet, but landlords think it's enough people to make this court a little busier. So just keep that in mind.
Okay.
All right. I'll see you all back on the 15th.
Thank you, Your Honor. Have a good day.
Thanks, Your Honor. Thanks, Pat. Ms.
Thank you.
Robinson, we'll be in touch.
Yeah.
Hopefully we'll be able to work something out and maybe we won't even have to come back on the 15th. Okay.
Okay.
Take care, Ms. Robinson.
You too. Have a good day.
All right. Thank you. Judge, this came also, you may have already saw this, but this is for the 2 cases. Okay. Is Ms. Parak, okay, Ms. Parak is here and Mr. Conker is here. Good afternoon. Good afternoon.
Afternoon,
Good afternoon.
61358. On behalf of defendant,
Calling case number 233-45171. This is Mathis Okulume versus Ardell Early and all occupants. May I have appearances?
Kathleen Parock, your Honor, P 78404 on behalf of the plaintiff.
Aziz Khankar, on behalf of defendants, 61358.
Thank you. All right. I'm going to ask this. Are parties able to resolve this matter?
No, we are not, Your Honor.
I believe I have solved the problem if she wants to listen to me.
Oh, okay. All right.
Judge, I would like to refer to the two-page flow chart that I filed with the 552023. Having, with your court, and she has a copy also. On the second page, I did a calculation. He paid $11,400, the plaintiff, and plaintiff has a outstanding tax bill of $3,939 with the county and $2,770.
Hold on, Mr. Conker.
Just very.
What are you talking? What are you? Can you start over? Because I'm.
The second page, Your Honor, flow chart.
Of what?
Here, the 552023. I filed with your court and Ms. Farag also. On the second page of the cover letter. Then going to the third page.
Let me find the page first, counsel.
Okay.
It's a flow chart.
Yes, sir.
Okay, I have the flow chart.
I don't see the flow chart. Can we say again where it's at?
It's not really a flow chart, but it's a document listed 1, 2, 3, 4. It's titled flow chart, so it is a flow chart, but
Oh, okay, Your Honor.
it's basically it looks like.
On the second page.
Okay, let's go through. Okay, on the second page of the flow chart.
Yeah, item number 6. The plaintiff paid $11,400 and he has an outstanding bill of $6,710 outstanding tax. I suggested to Ms. Parak earlier that I'd like to have my client pay $5,000 and take over the $6,710. Then my client's obligation will be $11,710. And then they will make a payment. And then I'll prepare a quitclaim deed, put an escrow. Once the payment is complete, then we're out of here. And we don't have any.
Your Honor, we cannot accept that. My client paid over $11,000 to the treasurer. They're only offering us $5,000. And we made an offer for settlement before. It was denied. That offer for settlement hasn't changed. Well, it might have changed because it's been a while, but Mr. Opposing counsel did also give me the offer of his $5,000 for settlement. And again, there's no meeting in the minds for settlement.
Can I respectfully answer this question? Your client right now owes $6,710 in taxes.
What does that have to do with anything?
It has to do with the settlement because of the fact that if my client takes over the pay $5,000 and takes over their taxes, my client will be paying $11,400, $11,710. So, and they'll be they will not have the obligation to pay the taxes. In other words, they get $5,000 and get rid of the another $6,700 in taxes. I think it's a fair settlement. If she wants to go to circuit court, because I did check with the state Supreme Court Administrative Office, Your Honor, I confirmed that this court does not have concurrent jurisdiction. I could not get a letter from the administrator because he's out sick on leave, Otherwise, I would have produced that. So in the final analysis, she would have to take this court to the circuit court for quiet title. And
This is not a quiet title issue. It's the eviction issue. It's the termination of tenancy issue. The court didn't have an issue with ownership. That was presented by you.
Your Honor, I have objected to that very carefully. That is, my clients do not have any landlord-tenant relationship with them. They don't. She cannot produce a lease or any kind of landlord-tenant.
If someone is an occupant counsel, then they don't have a landlord-tenant relationship in the sense where there's privy of contract between the tenant and the landlord, but they have a connection that they're an occupant of the property, and because they're an occupant of the property, this is the exclusive jurisdiction to remove that occupant of that property. So it doesn't matter if they have a lease or not. We do terminations of tenancy all day, every day in here.
Respectfully want to point out to the court that in the second page in Samson complaint, it says that your tenancy has been is being terminated, and there is no tenant relationship. In the Samson complaint, clearly said that it is. Let's check it with that. So if you want to go over the flow chart, Your Honor, filed 4 cases, and there is no enough time to review all those things. So I had to summarize this 67 pages of document.
And I read your motions. I read your motion. Case number 1. That is closed, correct?
Yes, Your Honor.
That includes.
Case number 1 is closed. That's not relevant.
Second case, she made mistake in the name of the plaintiff. So she keeps making me work. I don't have.
That case was not in front of me, and that case is closed.
That case is not closed, Your Honor.
Your Honor, it was closed. I filed it. It was not, but then it was dismissed.
You filed an amendment for the name of this.
I'm going to check it right now and tell you status. 22398-025.
Clinton, case closed.
Case is closed. Dismissal without prejudice is entered. Case number 3. Why is this relevant?
Number 3 is relevant because she filed this case and I have produced documents to the courthouse. She said that somehow it got filed by somebody else. It was in her own handwriting, if someone sent complaint, and in her office with the case number and the hearing date and time. So she is denying that she didn't have nothing to do. That case I filed a motion to summary motion, and this court clerk called me, and I paid a $20 filing fee, and then it was supposed to be heard by her. Found out that this case was completely botched up. The property address was 9,000 East Jefferson. So I don't know how she come up with all this weird cases. She denied this. I sent with my filing last time. I had my carrier take it to the courthouse, and you should see it in your package that she's the one who filed that case. Judge Brew.
2-3, it must be 2-2-3-9-8-7-7-1. All right, this case number 3, that doesn't even show up in the ROA. The 2-3-3-9-8-7-7-1, and we're currently on 2-3-3-4-5-7-7-1. So that case is that number wouldn't even work. So
Your Honor, she keeps filing cases, and I have to keep responding, and she keeps making mistakes and over and over. Then the last cases are of his.
Mr. Compton, what is the relevance of this? What is the relevance of this? Why are you telling me this?
Relevance is, Your Honor, if she kept with one case and completed, there would be no 4 files would not be opened up at the courthouse. I would be able to complete the case properly. She did not even file a motion with the initial court filing with Judge Alicia Jones.
Are we talking about the case ending in 2-3-3-4-5-1-7-1 LT? If we're not out, all these other cases are closed.
Your Honor,
I don't these cases.
That she used the same date, 11/22/2022, the same like a motion.
Okay. Counsel Parat, did you, in the case ending in 2-3-3-4-5-1-7-1, was the notice to terminate, was the notice a new notice, or did you use an old notice for that matter?
The notice I used for 171 was the same notice I used for the case with Judge, oh, please forgive me, Your Honor. The case with Judge McClinton, which is 025. I did have a mistake on the summons. I immediately filed the motion. At that hearing, both of us were present. She explained, Ms. Parak, if you dismiss this case, you can refile it tomorrow. It will be heard faster, and then you can fix your mistake. So yes, I used the same notice. Everyone was there. Everyone heard. We still required to have the property back. I did use the same notice. And as I've pointed out in my brief, a notice has to be given. That is true. And the notice was given, and we cannot file a case until after the notice. So when the notice expired, we filed, we had a mistake. Then we were asked to refile the case immediately, and we did, Your Honor.
So the case was dismissed. It's the same issue, same defendant, same parties, same address.
Yes,
as
so
the one with Judge McClinton.
So, Mr. Conker, how, when all parties were there present at the previous dismissal, how is it that your defendant is harmed by lack of notice?
Your Honor, my defendant is harmed because of the fact that the defendant's attorney had to be present in every one of the repeated cases. She could have.
Hold on. Whoa. How, you said he's harmed because you had to be present at the cases?
Your Honor, because of the fact that my time is not free. She keeps filing 4 cases for the same, against the same party, same with identical issues. And how does she, think that my time is?
We're talking about McClinton, the case that was filed, it was dismissed, and then she refiled. So you got a dismissal. That's water under the bridge.
She filed the Judge Brew cases. That was the next case she filed.
Okay, and the case number doesn't even plug into the computer, so I really don't know which case that was.
Yes.
Judge, I'm going to firmly state I did not file that case. I do not know what he's talking about. I just want that on the record.
Can you type in Brea Patterson? Thank you. B-R-E-A.
B-R-E-A.
Yeah, and then Patterson. Yeah. Brea Patterson and that.
Let me try it another way, Judge.
Okay, so what was the harm, Councilman?
Your Honor, I would respectfully request, Your Honor, if I have to attend in the four different, I have to bring up the old record, and because you would have difficult time to follow everything, because if I want a reference, then you have to go through the four cases for all files, you know, and that's why I have to spend time in summarizing for you so that you could easily understand what's going on. Because without some kind of reference, you would be able to decide anything. So, and then on top of that, you know, may I complete the other? She also asked Your Honor so that she could file a response to my 523 document. She filed about that.
I can't even hear you, Mr. Conker, and you know we've had this problem from the beginning.
She misquoted the, she took out the chain citation and put a point in between, you know.
I didn't hear what you said.
She made a serious mistake, and I did file the response to that.
If I may address that, Your Honor. Your Honor, I'm dyslexic. Okay. I don't want that to be out personal known, but it is. And I try very hard when I do my stuff. Did I make a slight typo? I did, Your Honor.
It's not typing.
It's under number 3 of what I typed in. It does not change what the actual law is. Instead of putting a period, I put the word but and added 2 sentences together.
No, you.
I put the word but and added 2 sentences together. The case citation is correct. Inside it was cited to another case. So I do have double case citation, which is not there. That is a typo, but it does not change the law that is there. It is a typo. I will admit it freely, Your Honor. And it says, mere peaceful possession alone is not sufficient to acquire title by adverse possession. It should be a period. I put the word but. There must also be an element of hostility. That is the correct law. Opposing counsels also cited that.
Why are we even talking about adverse possession?
Your Honor, that's a great question, because adverse possession happens to actually be someone who has color of title, and you have to go to the circuit court. And if you have color of title, you are allowed to go to the circuit court and sue for the actual title of it. Mr. Conker is using that as a way to say that his client has control of this property and has a good title. My client bought it at a tax sale. His client did not pay the taxes. He says his client has been in peaceful possession for 50 years. That may be true, Your Honor, because they've owned it before, but that is not hostile. As I have pointed out, it is something that is irrelevant to this case. It's a tax sale case.
Please respond.
That is it.
Let me respond. In this case, what is the plaintiff? That I will pay this off, taking federal loan. How is it hostile?
It's not adverse possession. Who is this property? Who did the property? Who lost the property in taxes?
I do not understand the question, Your Honor.
Was the property lost at the tax sale? Was your client foreclosed, Mr. Conker?
No, my client did not lose possession.
Was your client? Did Wayne County Treasurer's Office foreclose the property that your client Did they foreclose the property? What is this?
The plaintiff did not get a deed from the warranty deed from the county.
Okay, judgment
Which
for plaintiff. Judgment for plaintiff. I have a quit claim deed. It came from the Wayne County Treasurer's Office to Ms. Parak's client. This case, it was filed once. This is filed twice. You filed a motion saying that the court doesn't have jurisdiction over landlord-tenant cases.
Yes.
Which is, you also filed saying that adverse possession applies. It doesn't apply. You keep making these arguments. You keep trying to negotiate. I don't understand what the basis of your argument is. I still don't understand what the basis of your argument is. Parties admitted to being in front of Judge McClinton. She dismissed the case and said you can refile it immediately, which is what she did. You can't demonstrate any harm that was caused to your client who was attending the last hearing and knew that a lawsuit was coming immediately. And now you're fighting the notice issue when you really probably need to be in Third Circuit arguing or fighting for the property there. But it's not here where you're gonna win an adverse possession claim or convince me that I don't have jurisdiction at 36th District to conduct an eviction. I mean, I'm not going to conduct the eviction, but enter a termination of tenancy judgment. So I'm going to give you, before I make this judgment, please, what issues are still relevant that would lead this court not to enter a judgment in favor of the plaintiff?
Respond, Your Honor.
Yes, absolutely.
Respectfully put in the record that my client never lost possession of the property, regardless of any kind of judgment. I
can't accept that argument because I have a quit claim deed from the Wayne County Treasurer's Office. If I don't give any weight to this deed, then that means every other deed that comes in front of me, I have to just say, oh, well, maybe they don't get possession. Oh, maybe, well, the governmental function is ineffective and we do whatever we want to do. Because what's the alternative to not honoring a deed? It's not a warranty deed, but you don't have a deed that's presented greater than that. And your argument is with the Wayne County Treasurer's Office. It's not with 36th District, and whether the foreclosure was proper, they already have a deed.
Your Honor, I have already submitted a well-researched brief, and it is in your possession, Your Honor. Adverse possession is a question of intent. It's a question of fact. It's not just because somebody got a judgment. That is not accurate. That's why I said that election of remedies. You can order this case to be transferred to the circuit court, then I'll take it from there. That's why
But you need to, because the person has a deed, and because they have a deed, they have a right to regain possession of their property. So let's go through your motion, all right?
My motion is
summary dismissal in lieu of an answer. I'm going to go through your motion. You said that Parak knowingly made misrepresentations. I'm going to ignore that. I'm going to deny that part of the motion. You're bringing up she made misrepresentations because this property was occupied by the Earlys for 50 years. Ardell Early paid $10,000 and conveyed it in 1992. That's not relevant.
Your Honor, may I?
Hold on, I'm not done. No, not yet. Issue number 2, whether plaintiff made representation as to pendency of a landlord-tenant case in 36th District, which has no equitable jurisdiction. Defendants are not breachers in 36th District is not a proper form. That's incorrect. Res judicata will not apply, does not apply in landlord-tenant evictions. You know why? Because the date changes. The date changes. So it's not the same issue because they're still in the house. You're not gonna, just because one eviction wasn't dismissed, it wasn't dismissed with prejudice. Was it?
No, because it could have been, because that's what the Judge Coleman, Alicia Coleman, said she's gonna do. But that case was transferred to Judge Sean Jackson. And he did not quite understand the whole situation. That's why he signed instead of with prejudice, he signed without prejudice. I already immediately filed a response to Judge.
How can a real estate eviction be dismissed with prejudice?
Because of the fact that the plaintiff's attorney did not attend the case.
Let's take it up.
Waited for 6 or 7 hours ago. She did not call, and she had no good excuse. She did not file a motion or any kind of affidavit with a good cause. She did not do that. So the judge asked her to do that. She did not do that. I realize a person may have problems. She may have problem on that date. She could not come to the court, but she could easily call the court. She didn't do that. She did not file a response.
What are we talking about, Ms. Barak? What is
Connor,
it?
with all due respect, I missed a pre-trial. I had an emergency that day. And I had an emergency inside my office. I did call the clerk the next day and she told me, Ms. Parak, it was dismissed without prejudice because you missed it. And therefore, I issued a new notice that time to get another case started because the notice that I had was old and was defective, not necessarily defective, but it was old and it was time for a new notice. You're right. I did not go back. She did not order me to go back and reopen the case. She said, Ms. Parak, it was dismissed without prejudice. That's what was in the ROI. Now, opposing counsel filed a judgment, a default judgment, and she refused to sign it. Months went on when finally I was starting to be contacted by the court asking for a dismissal. I had explained the reason why the case was dismissed, that it was my fault. I have never said that it wasn't my fault. And I did finally submit a dismissal. However, the court redid it, which they had to because it was coming from me and it wasn't, I was the one at fault. So the court did not, and never in the register of actions did it dismiss with prejudice.
It was not because
again, it was a pretrial, Your Honor, and the first pretrial, generally it is always dismissed without prejudice. You then have a choice whether or not you want to go back and open up the case. And or a landlord-tenant case, if you decide to move forward with a new notice, it's a new case.
If you dismiss something with prejudice and landlord-tenant, it ruins the marketability of a house. Just think about it. It doesn't, I mean, it may be possible, but I haven't seen a situation where that makes sense unless the occurred.
Your Honor, she said she spoke to the clerk, and she didn't talk to the judge, but I did.
I'm not going into that. I don't care about that. Okay. Issue 2, whether plaintiff violated the legislative purpose of GPTA. I'm going to deny this because it lacks relevance to this landlord-tenant matter that we're in front of. You're saying the conclusion, Mr. Aflume has no intention to revitalize the property. You don't know that.
Yes, Your Honor.
But how do you know what you're presenting to me?
Your Honor, Mr. Aflume wants money. There's no way.
I don't care what he.
How can he?
Aflume paid $11,500 more or less, and he's asking for $20,000 from defendant. Thus, he is trying to make a quick profit. That doesn't matter to me. That's not my business. That's not my business. I don't go policing people's deals. That's none of your business either. Unless, I mean, I guess it is because you're in negotiations, but that doesn't have anything to do with me. And negotiations aren't supposed to be presented anyway. All right. Issue number 3. Issue number 2 is denied. Issue number 3, whether plaintiff's attempt to sell the land and collect excess money has converted him into a debt collector with the assistance of counsel Kathleen Karat, who did not provide a debt validation notice. So are you saying that Ms. Parak needs a debt validation notice and she's considered a debt collector because she's filing a termination of tenancy complaint? Is that your position?
She's trying to collect money way more than her client paid. Also, there's a case in the Oakland County Circuit Court. It was Raffaelli versus Oakland County Treasurer.
No. We're jumping to the
that case is relevant. That case is relevant here. I quoted that case in this.
Okay. All right. Go ahead. And then Wayne County hasn't given back a cent yet, but go ahead.
And it is in the brief. Any access property belongs to the rightful owner. So therefore it will be under 14th Amendment. That money that they're going to collect does not belong to Mr. Okuma. It will belong to the person who is now.
Go get it from Wayne County. Go get it from Wayne County. She doesn't owe you that money. They didn't sell the property on auction.
Your Honor,
how is that even an issue? How is that an issue?
GPT
relevant to me? How is that an issue relevant to 36th District Court? You're saying that someone's profit from an auction, a governmental municipality's profit from the auction based on case law, you're saying that they can't profit. And it's the Supreme Court ruling that said municipalities can't profit. You're 100% correct on that. And I don't know what's going to happen. I don't know how much money is going to be given back, but Ms. Parak's not going to give it back. Ms. Parak's client's not going to give it back. And 36th District is not going to give it back to you. So why are we even talking about this right now?
It was auction for auction. It was $4,900. $4,905 was the amount owed. And he meaning that plaintiff was the successful bidder for $11,400, I believe. Therefore, the money that is the excess money doesn't belong to him. Your Honor, also GPTA, you summarily rejected my argument. GPTA is intended for neighborhood development and also because that is the purpose, And she's quoting GPTA all the time, but yet the legislative purpose of GPTA is neighborhood development and bringing the money to the treasury and for purpose of redevelopment. It is not just to make a quick profit.
What? No. I'm not even accepting that argument. That's not even relevant to this court. This is a landlord-tenant auction. I mean, this is an eviction for termination. This is a request for termination of tenancy post-auction purchase. They have every right. They have every right to their property.
Your Honor, this is not a landlord-tenant case. It is a misnomer because I have heard there are other attorneys have argued before the same situation. In other words, the people who are buying properties from the land bank and GPTA, they're using this court as a short circuit to get a title to the property because they should be going to the.
I'm not granting any title, but I am granting possession. I am going to grant possession. I'm going to grant possession.
Your Honor, as a practical matter, they could not get a possession of the property because their remedy at law is adequate. Law is adequate. They cannot show irreparable harm because the fact that the money damage is the only thing that you can award, Your Honor. Because
all right, Mr. Conker.
Money damage is because the fact this building is inside property. In 1967 during riots, there's part of the building got burned down. My client's father, he boarded up the outside and then it became a part of it was a small portion.
Ms. Parak, because I asked you to stop talking earlier, counsel, you just ignored me, so I just muted you. I'm gonna miss the mute button next week. Ms. Farad, how much time are you willing to give Mr. Early?
My client, due to the fact that this has been ongoing for many, over a year, my client is asking for 10 days.
Now, when was this case filed?
This case was filed originally in the January, then it was refiled in March.
2021.
Okay, all right, well, all right, so how much time does your client need, Mr. Conker?
Your Honor, my client cannot move out of the property. This is the only repair shop in the area. And Your Honor, this property that is 1727 is not, it cannot be recognized from the outside. You know, it have to go inside my business, inside my client's business. There's no way they can occupy the property, because if you send somebody over from the court or the police station or whatever you want to do and take a look at it, because
it's not an issue of occupancy or whether the property is habitable or not. It's just being there. Maybe they want to put a picnic chair in the middle of this rubble. They have every right to do it as a property owner.
Your Honor, let me ask you a big favor. I want some alternate dispute resolution in this matter. Okay, instead of getting a judgment right now.
You are not entitled to that. There's a judgment by hearing. This is a termination of tenancy matter. Mr. Early must vacate by June 12, 2023.
How is it vacate, Your Honor? Because
I give them until June 20th. I'll give them until June 20th, 2023, or a writ of eviction may issue.
Well, Your Honor, I'm not quite able to make sense to you, because the fact that this property, this small portion, it is within the business BTS auto repair shop. It is in the repair shop. If they want to have somebody go inside the property and sit down there with a chair, and that's the only way they can occupy. The money damage is the only remedy that is to be offered, because money damage is adequate.
The case is, Mr. Conker, you can appeal this matter, and I know you will. You can appeal it and challenge it, but this case is resolved in this courtroom.
What is the date?
5171. There's a judgment by hearing for June 20th, 2023.
I'll submit that today, Your Honor. Thank you.
You're welcome. And for the record, I denied your motion.
For the record, I requested an alternate dispute resolution. For the record, this is improper, because this court does not have equitable jurisdiction, and only money damage is adequate. Therefore, possession is not a proper remedy.
Okay, so you're saying that money damage is the only remedy that I can grant in 36th District Court landlord tenant?
I'm not telling you you're limited to that. I'm saying that
you just said the exact same word, that is the only remedy. Money damages is the only remedy, and we have no equitable powers. And I'm not going to whether or not we have equitable powers, but I can tell you that I have power to issue a termination of tenancy judgment, and that's not a monetary judgment. So I must be able to do something outside of issuing money damage. So judgment by hearing June 20th, 2023. That's the parties must vacate by that date.
How is going to vacate, Your Honor?
I don't know. All occupants. Is there any actually, I'm just gonna leave it as it is. It's not my case. So
It's not a practical matter, Your Honor. As a practical, matter, it cannot be done.
your motion wasn't practical, and we're moving on, counsel.
Okay, Your Honor, if you say so, but I do think that.
You didn't even put your camera up today. You didn't even put your video up to even argue the motion. And you don't have to now, and that's not, I mean, it's just like, I gave you time to speak. I gave you time. I didn't cut you off. I mean, I cut you off a few times when it was irrelevant, but you've had every opportunity to make this argument, and you spent time making the argument, and I didn't even highlight the fact that you're just accusing and opposing counsel of all types of wrongdoing and asking for sanctions and whatnot. But hey, your parts law, you're arguing on behalf of your client. That's not the issue. The issue is that you didn't have an argument that would defeat a landlord-tenant termination of tenancy judgment with the deed in the file. So that's the final judgment. If you appeal it, there's fine. That's the thing, you're right. But today, I'm awarding possession to the client who was presented a deed. Go ahead.
The record, this is a proper case for possession, Your Honor. And thank you.
I didn't hear what you said.
It's a proper case for adverse possession. Not for somebody else, because it's a practical. So thank you for your time, Your Honor.
Thank you for the effort. You all both dedicated a lot of time to this, so that's appreciated by the court, but I'm still rooting.
Your Honor, I've been a very respectable member of the bar, and in your courthouse, all the people that I used to know there are retired or died. Judge Marian Moore was my classmate. She passed away. So they never questioned my ability to make.
Well, I'm questioning it. I'm questioning it, and it may not be your ability, but I'm questioning your rationale for this case. You may be a whiz at something else, but when it comes to landlord-tenant termination of tenancy and this specific issue, I disagree with you. So that's fair. I can disagree. I disagree with people all the time. And it's no disrespect, counsel. It's just
okay. Okay.
Tell me who takes on you and who doesn't. Thank you.
Thank you, Your Honor.
Thank you, counsel.
Thank you, Your Honor.
Well, our party's ready on Kenja Kelly. Or Mr. Yeah. And let's see. Is Tasia Murray here? Okay. I'm ready for you, Mr. Horka, or Mr. Richter, Attorney Richter. You have a case in here today?
Your Honor, I have two cases on Monday and I have some conflict. I contacted your clerk and she asked me to zoom in and ask you if we can adjourn the cases on Monday is the first hearings.
Okay. Talk to him, Judge. I don't think you talked to us.
No, you know what? He sent a message, a direct message to me.
Oh, okay.
He had to ask the judge or the clerk to get a new date.
You said for first hearings?
Yes, that's correct.
There's no need. There's no need. There's no need because you're not gonna, are you a plaintiff's attorney?
Yes, Your Honor.
You're gonna have a date for a second hearing.
No, that's first hearing, Judge. I have first hearing on Monday, 8:30 in the morning, and I have conflict.
Right. So come back on.
So I cannot. Okay, go ahead.
So come back on the second court date because it's gonna get adjourned anyway.
Right.
So you wouldn't be penalized for your non-appearance at the first hearing.
That's correct.
I'm not discouraging plaintiffs to only attend at the second hearing. I'm not saying only attend second hearings, but I'm telling you that you appearing at the first hearing may speed up the case, may make you aware of the issues earlier. However, you won't be penalized for your non-appearance. The case won't be dismissed for a non-appearance at the first hearing.
That's all I want to know.
Okay, so you're in good shape. Thank you for notifying the court, and we'll note and I guess look on the ROA or contact the court so you can get that second hearing date.
Thank you, Your Honor.
You're welcome. All right, calling case number 23347232. This is MBA Management Detroit versus Kenja Kelly.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
And Attorney Keon Bonds, P number 78423, appearing on the behalf of Ms. Kelly, who was present in court with us today.
Right, Ms. Kelly.
Hi.
Can you state your name?
Oh, Nikenja Kelly.
All right, thank you, Ms. Kelly. All right, were parties able to come up with some type of agreement?
Yes, we were able to come up with a move-out date. It will be a CD 4B. And if they do have to initiate and reinstate the hearing, it will be in all occupants. The move-out would be for June 30th.
All right. Okay, so it's conditional dismissal. Ms. Kelly, if you vacate by June 30th, this matter is dismissed. In the event that you do not vacate, a writ and a judgment would issue at the same time. A judgment and a application for an order of eviction could be applied at the same time without going to court. But based on this agreement, if that does happen, that judgment will be in all occupants. Do you have any questions?
No.
All right, did I miss anything?
No, Your Honor.
No, Your Honor.
Okay, all right, court satisfied. Thank you. Have a great day, Ms. Kelly.
Oh, one moment. May I have Ms. Kelly's permission to sign on her behalf for the CD?
Yes.
Thank you.
Thank you, Ms. Kelly.
Thank you.
You're welcome. All right, calling case number, let's see, what's the second case you all are on? Is that 239?
Yep, 239.
Calling case number 23347239. And this is Sherwood Heights Apartments versus Chitana Stewart.
Good afternoon, Joe Horka, P75969, on behalf of the plaintiff.
And Keon Bonds, P number 78423, on behalf of the defendant who is present with us today.
Thank you. And can you state your name, ma'am? Ms. Stewart.
Ms. Stewart is in a breakout room. I'm trying to move her back to the main room. That's what I'm working on doing right now.
Okay.
She's here though.
Okay, let's put the term, well, let's give it a second so we know she is fully aware of everything. We can pass this briefly. Don't go anywhere, Attorney Bonds, and then I'll call a few defaults and then we'll just. Oh, did she pop back in?
Let me go in here and get her. Hold up.
Okay. We can just wait. I'll wait. Thank you. Yep. I saw the truck outside. Oh. Oh. All right. Ms. Chitana Stewart, can you state your name for the record?
Yes, hi, my name is Chitana Stewart.
Thank you. All right, parties. What agreement were you all able to come up with?
We're going to do a judgment by way of hearing against all occupants only. Total balance due, including costs and June's rent, $12,288.83.
All right. And when shall that be paid?
On or before June the 30th, Your Honor, subject to any subsequent payment plans the parties agree to.
Okay. If you have any payment plans, make sure they're in writing, Ms. Stewart. And this is a pretty hefty balance to pay off by June 30th. So, but it's a pay or vacate by June 30th, and the judgment is in all occupants. So, good luck. Do you have any questions?
Could you repeat the amount one more time, please?
$12,288.83.
You said 12,000, not 1,200?
No, 12,000.
1228.83.
Okay.
Yeah.
Okay.
All right, Ms. Stewart, any questions?
No.
Okay, well, good luck and have a great day. You are free to leave unless Ms. Bonds wants to talk to you.
No, if you have any questions, you can always contact me through email or call me, but you're free to go.
Okay, thank you.
You're welcome.
All right. Let's do, are you done with every other courtroom, Mr. Harper?
Pretty much, Your Honor. I have one case elsewhere. That's it.
All right, well, let's see, we have a default. Let's call you defaults, and then consequently, counsel for Cox. He's got one case. Can you cover it? Okay. Calling case number, let's do these. Calling case number 2334-7234, MBA Management Detroit versus all occupants. And that is all occupants at 20450 Sorrento Street.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Defendant is failed to appear. Does anyone live at 20450 Sorrento? Appears that defendant is failed to appear. Counsel, are you requesting the court to take action?
Yeah, I'm asking the court to enter default judgment of possession.
Default judgment entered. Determination of tenancy. Defendant must vacate by June 12th, 2023, or a writ of eviction may issue. Calling case, that's case number ending in 7234. Calling case number 2334-7235, MBA Management Detroit versus all occupants. And that's all occupants at 17552 Ferguson Street. May I have a case?
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
All right, anybody on Ferguson? 17552 Ferguson. All right, I don't see anyone in the gallery or in the waiting room. Defendant failed to appear. Counsel, are you requesting a default judgment?
I am, Your Honor. This one might turn into a dismissal, but at this point, I would ask for a default judgment.
Okay. All right. June 12th, 2023 is the vacate date. If you feel like dismissing it, feel free. You have every right within, you have every legal right to do so. So I'll leave that up to you. Calling case number 2334-7236. This is MBA Management Detroit versus all occupants at 8634 Birch Road.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Does anyone live? Let's see, 7235. We gotta let It's like 7235 is here. Okay, well, let's finish the case. There's no one present at 8634 Burke Road. Counsel, what is your request?
I would ask for a default judgment, please.
Default judgment is granted. Defendant must vacate by June 12th or writ of eviction may issue. This is a termination Tennessee case. Defendant failed to appear. Let's see. Check fine. Mr. or Miss, is Matthias Zabala. Matthias Zabala.
Yes,
Do you live at 17552 Ferguson Street?
no, I'm just here to listen for the plaintiff side on this case.
Oh, you're on the plaintiff side?
Yes, just here to listen for the plaintiff side to speak.
Hold on. Do you work for MBA Management?
I know that this case was supposed to be dismissed, but I'm just here to listen if it was so, if it was really dismissed.
No, this case wasn't dismissed. So, are you an occupant of 17552 Ferguson Street?
No, I'm just here to listen for the landlord, and they told us that it was dismissed, and we're just here to listen for that, to what they say to us.
Okay. All right. All right, calling case number 23347241 Orchestra Towers versus Laverne Bolden.
Afternoon, Joe Horka, P75969, staying in place of Mark Landau for plaintiff.
All right, thank you. Is Laverne Bolden here? All right, does anyone reside at 3501 Woodward Avenue, apartment 1012? Defendants failed to appear at the last hearing as well as this hearing. It's a complaint for termination tendency. Counsel, do you have any requests for the court?
Yes, Your Honor, I would ask the court to enter a default judgment.
All right, then it must vacate by June 12, 2023, or writ of eviction may issue.
I think that was it, and I don't think I see you tomorrow, so hope you have a good weekend and see you bright and early Monday.
All right, gotta wear dress pants now. No more sweats with the suit.
I am not looking forward to it, but we'll do what we gotta do.
Are you covering, it's a Tasia Murray default for Cox. I know counsel was here, but I'll wait around for him.
I don't think he's expecting to be back, so I can stand in.
Right, thank you. Calling case number 23347244 TRGRF owner LLC versus Tasia Murray and all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
All right, is Tasia Murray here? All right. Tasia Murray isn't here. Does anyone live in apartment 25J at the Riverfront, on Riverfront Drive?
I think this is a dismissal, Your Honor. Resident vacated.
Right. The court will dismiss this matter without prejudice. It may be in the chat now that I think about it. All right. Well, have a great weekend.
You too.
Okay. I'll see you in person. Okay, Harris,
Harris.
Yes, our docket is completed. What case are you here for?
I guess I was here for that case. I just got the times mixed up. I thought it was at 2, so I just missed the court date.
Why don't you say anything?
I'm just looking at the paper. I called the number, and I've been calling the number since 2 o'clock when I noticed it. And I've been on the live stream on YouTube, and I noticed that. I don't know. I don't know.
Hold on, is this Tasia Murray? Is this the Riverfront 251?
No, this is Asia Harris. I'm sorry. I
Right.
thought you called Asia. I thought you called Harris.
No, I did because I don't have any cases left. What's your case number?
233-47205.
10 o'clock this morning.
Okay, Kimberly Trimble versus Asia Harris. Yeah, Ms. Trimble was here too. Yeah, I believe we entered a default judgment on that. So if you can get in touch with Ms. Trimble, and you all can work something out.
Okay.
But what judgment was granted? There's, I don't know if legal aid can assist. I don't know if you all do post-judgment counseling, but legal aid may be able to assist, but you can possibly file a motion. You can file a motion, but I will call the landlord. I can't give you legal advice, but maybe you should talk to someone from legal aid.
Okay.
If anyone's willing to talk to her.
Yeah, we can move her into a breakout room, Your Honor, and speak with her.
Okay.
Thank you.
So you're welcome. Good luck. At least you were 5 hours late, or 4
I'm
hours
sorry.
late, and not
I'm
4
sorry.
minutes, if that makes you feel any better, but you definitely missed it.
I know.
It's all right.
Well, thanks anyway.
You are welcome, man. You're in good hands. Hopefully you all can help her out, or we'll see. So have a great day, Ms. Harris. I'm not going to close out. I'm going to leave this open so that you can talk to legal aid and hopefully work that out.
Okay. You have a good day too.
All right, thank you.